TV, saat ini saya sampaikan langsung di Aula Java Heritage Purwokerto pada tanggal 4 Oktober 2023. Dan sejak pantauan kami pukul 07.00 waktu Indonesia Barat hingga sekarang, di samping kanan serta kiri saya ini sudah ada para peserta konferensi internasional yang turut andil dalam acara ini berjumlah 850 lebih baik offline maupun online, serta dari 33 perguruan tinggi. Hadir pembicara pada acara ini yaitu Profesor Dora Marinova dari Curtin University Australia, Asisten Profesor PN Roslinda Muhammad Fazil LLB LLM dari Universiti Kebangsaan Malaysia, esok Profesor Christopher M. Kaysen dari University of Washington, Profesor Honoris Causa Unsoed Dr. Sanitiar Burhanuddin SHMH, Jaksa Agung dari Kejaksaan Agung Republik Indonesia, Profesor Nurul Barizah SHLLM PhD dari Universitas Erlangga, Profesor Dr. Hipnu Nugroho SHMH dari Universitas Jenderal Sudirman, dan terakhir yaitu Profesor Dr. I Gusti Ayu Ketut Rahmi Handayani SHMM dari Universitas 11 Maret. Oleh karena itu pemirsa, mari kita saksikan dan ikuti proses acara The Third ICOLGAS International Conference on Law, Governance and Social Justice Fakultas Hukum Universitas Jenderal Sudirman. Ladies and gentlemen, report in Krishna Ballroom Java Heritage Purwokerto, and since our monitoring at 7 a.m. West Indonesia time, there are already participants more than 850 people on online Zoom meeting and offline. It's now my pleasure to introduce our guest speaker international conference on law, governance, and social justice from Curtin University Australia, Universiti Kebangsaan Malaysia, University of Washington, Attorney General Republic of Indonesia, Erlangga University, Jenderal Sudirman University, and 11 Maret University. Let's begin the third ICOLGAS International Conference on Law, Governance, and Social Justice, Faculty of Law, Jenderal Sudirman University.
Oke, baik, selamat pagi Bapak dan Ibu, selamat datang di Krishna Ballroom Hotel Java Heritage Purwokerto. Pada kesempatan kali ini kami juga mengundang seluruh kejaksaan tinggi yang ada di seluruh Indonesia dan kejaksaan negeri yang ada di seluruh Indonesia.
Good morning, ladies and gentlemen. In this conference, we also invite all the prosecutor's office join with us in Zoom meeting, maybe.
Conference on Law, Governance and Social Justice.
Pembangunan hukum di Indonesia secara umum sudah sesuai dengan harapan masyarakat. Hal ini dapat dilihat dari berbagai upaya pemerintah melalui perumusan perundang-undangan atau legislasi nasional dan juga bagaimana melakukan pembaharuan sesuai dengan dinamika dan kebutuhan masyarakat. Indonesia ini begitu luas dan juga merupakan negara yang sangat majemuk, plural, sehingga bagaimana pembangunan hukum ini bisa menjangkau semua elemen, semua anggota masyarakat seluruh Indonesia yang terdiri berbagai suku bangsa, budaya, etnik, agama, dan juga tersebar di ribuan pulau. Bagaimana kita memberikan akses terhadap keadilan seluas-luasnya dan juga memberikan pengayoman yang seluas-luasnya terhadap para pencari keadilan, dan juga disediakan upaya hukum bagi para pencari keadilan tentunya ya. Dan selain itu harus ada pembenahan baik dalam konteks peraturan perundangan yang harus disesuaikan dengan perkembangan zaman dan juga mengenai integritas dari para penegak hukum dalam menjalankan tugasnya.
Keadilan yang bersifat restoratif, satu pemulihan korban, dan keadilan itu tidak hanya di pengadilan. Ada teori justice of omnium bahwa keadilan itu ada di mana-mana. Oleh karena itu, Fakultas Hukum selalu memberikan suatu kontribusi pemahaman bahwa keadilan itu bisa di kepolisian. Artinya apa? Kita sebagai akademisi, kalau memang di tingkat keadilan itu di kepolisian, oke, cukup di kepolisian. Atau sebelum di kepolisian, dengan mediasi, itu bisa. Atau di kejaksaan, atau di pengadilan. Justice of omnium, inilah yang sekarang kita kembangkan Fakultas Hukum. Sehingga apa? Asas cepat biaya ringan yang selalu dikembangkan di dalam KUHP itu betul-betul terimplementatif di masyarakat.
Kontribusi Fakultas Hukum Unsoed yang didirikan sejak 1981 sudah meluluskan mungkin lebih dari 7.000 alumni ya. Dan mereka banyak bekerja di berbagai institusi, baik institusi pemerintah, kemudian juga swasta dan juga NGO dan sebagainya.
Banyak pula dosen-dosen hukum Unsoed yang dimintai pendapat kepakarannya mengenai kasus-kasus hukum yang terjadi di Indonesia. Selain itu juga mahasiswa Fakultas Hukum Unsoed melakukan KKN atau kuliah kerja nyata dan juga MBKM, Merdeka Belajar.
Memberikan kontribusi baik masyarakat lokal, regional maupun nasional. Dengan kondisi Fakultas Hukum Unsoed yang sudah ada S1, memberikan pemahaman tentang aturan-aturan hukumnya, normanya harus kuat. S2 yang memberikan bekal pada mahasiswa untuk berpikir pada asas. Dan S3 program doktor ilmu hukum yang memberikan pada para mahasiswa untuk memberikan nilai-nilai hukum yang ada, nilai-nilai filosofi.
Ya, Fakultas Hukum Universitas Jenderal Sudirman menyelenggarakan pendidikan dan pengembangan ilmu hukum yang berbasis moral, berkearifan lokal, dan berdaya saing global, sehingga kami mencoba untuk mengkombinasikan antara teori dan praktek terkait dengan pengembangan keilmuan hukum yang sifatnya lokal dalam rangka untuk meningkatkan kualitas secara global.
Fakultas Hukum Unsoed sebagai salah satu fakultas yang ada di Universitas Jenderal Sudirman berlokasi di sebuah wilayah yang tergolong terpencil dari sisi kewilayahan, mempunyai keunggulan kaitannya dengan kearifan lokal yang ada.
Good morning, ladies and gentlemen. Welcome to the third International Conference on Law, Governance and Social Justice. Before we begin, I request all of you to kindly switch your mobile phones to silent mode to avoid interruption. Thank you for your kind cooperation.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. I, Deris Farandusdiana, and my partner,
Eni Dwi Cahyani,
your masters of ceremony for this conference, on behalf of the organizing committee, we would like to extend our appreciation for your presence today.
welcome to the Third International Conference on Law, Governance, and Social Justice. First of all, let us praise the Almighty Allah Subhanahu wa Ta'ala. Because of His blessing, we can attend this event without any obstacles. Honorable the Attorney General of the Republic of Indonesia, Profesor Dr. Sanitiar Burhanuddin SHMH. Honorable Director of Jenderal Sudirman University, Profesor Dr. Insinyur Ahmad Sodik Master of Science Agriculture IPU.
Honorable the Dean of the Faculty of Law, Jenderal Sudirman University, Profesor Dr. Muhammad Fauzan SHM. Honorable the Chairman of the Third International Conference on Law, Governance, and Social Justice, Dr. Teddy Sudrajat SHMH. And to you all, respectable speakers and distinguished guests, thank you so much for coming, attending this event.
Our event today will consist of opening ceremony and also the first session.
Second, singing Indonesia National Anthem.
Third, opening prayers.
Fourth, welcoming dance.
The fifth, opening ceremony and welcoming remarks.
The sixth, keynote speech by the Attorney General of the Republic of Indonesia.
The next, plenary session 1 and session 2.
9, parallel session 1 and also parallel session 2.
Lastly, the closing ceremony announced the best paper, the best presenter, and public information.
Ladies and gentlemen, we've come to the second agenda, singing the Indonesia National Anthem, Indonesia Raya. Please stand up to sing the national anthem to all participants.
Ladies and gentlemen, please be seated. The next agenda is the opening prayer that will be led by Mr. Hermawan Prasojo, SHMH. Mr. Hermawan, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, regardless of our diverse belief. If you would kindly adjust, allow me to lead us in a prayer following the Islamic faith in Indonesia. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Hamdan syakirin, hamdan na'imin, hamdan yuafi ni'amahu wa yukafi'u mazidah. Ya Rabbana lakal hamdu kama yanbaghi li jalali wajhika wa adimi sultanik. Allahumma salli wa sallim ala sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Ya Allah, ya Tuhan kami, segala puji serta syukur tercurah kehadirat-Mu atas segala rahmat dan karunia yang telah Engkau limpahkan kepada kami. Sehingga saat ini Engkau pertemukan kami dalam acara The Third International Conference on Law, Governance and Social Justice, Fakultas Hukum Universitas Jenderal Sudirman. Untuk itu ya Allah, ya Rahman, ya Karim, jadikanlah acara ini sebagai acara yang Engkau ridhoi, yang membawa barokah, rahmat, taufik, dan kemanfaatan yang banyak bagi kami semua. Ya Allah yang maha benar, pancarkanlah cahaya kebenaran di hati kami, pada pendengaran kami, pada penglihatan kami, agar kami dapat melihat bahwa yang benar tampak jelas benar, dan berilah kekuatan untuk mengikutinya, serta dapat melihat bahwa yang salah itu tampak jelas salah, dan berilah kekuatan untuk mampu menjauhinya. Ya Allah Tuhan yang maha mulia, anugerahkan kami kecerdasan dalam berfikir, kesungguhan dalam berkarya, keikhlasan dalam bekerja, dan kemudahan dalam segala urusan kami, agar kami dapat turut serta membangun negeri kami Indonesia tercinta menjadi negeri yang baldatun thayyibatun wa rabbun ghafur. Ya Allah, bukakanlah untuk kami jalan keluar dari segala kesulitan, ajarkan kepada kami apa yang belum kami ketahui, dan sempurnakan segala kekurangan yang kami miliki. Sesungguhnya hanya kepadamu lah kami menyembah, dan hanya kepadamu kami mohon pertolongan. Ya Allah Tuhan yang maha pengampun, ampunilah dosa kami dan kabulkanlah doa kami. Rabbana taqabbal minna innaka antas sami'ul alim wa tub alaina innaka antat tawwabur rahim. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Mr. Hemrawan. As our welcome gesture to you, as we are here in Banyumas, Central Java, we would like to present a welcome dance that will be presented by several students of the Law Faculty of Jenderal Sudirman University, that are Siti Fatimah, Firda Putri Mediana, Andini Oktavia Rahma, Ganindya Putri, and Miranti Nur Azizah Afianto.
This performance represents the warm hospitality of the Banyumanis people and the rich culture of the Banyumas. The Ngerong dance is a new dance creation accompanied by Calung Banyumasan. The Ngerong dance is taken from the word ronggeng, known today as lengger, and it gets the ngafix nge, which means to do. So Ngerong is doing lengger or dancing lengger. This Ngerong dance is usually danced to welcome guests or as an opening ceremony in Banyumas Regency. Please welcome the traditional dance of Ngerong Banyumasan.
for the beautiful performance. Honorables, distinguished speakers, ladies and gentlemen, the opening ceremony of the third International Conference on Law, Governance, and Social Justice is going to commence with a welcome speech. And I would like to invite the chairman of the third ICOLGAS. Please welcome Dr. Teddy Sudrajat, SHMH.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Peace be to the peace and God blessing be to you all. Good morning for everyone. The esteemed Rector of Universitas Jenderal Sudirman, Profesor Dr. Insinyur Ahmad Sodik, Master of Science Agriculture IPU, the distinguished deans, the Dean's Faculty of Law, Professor Dr. Muhammad Fauzan SIM, and all of the deans in the Universitas Jenderal Sudirman, and also the head of institutions in Universitas Jenderal Sudirman. All of the respected invited speakers, the first Professor Dr. St. Burhanuddin as the Attorney General Republik Indonesia, as an honorable professor at Universitas Jenderal Sudirman, thank you very much, sir, for your comings to join the conference as a keynote speakers. Professor Dr. Dora Marinova, thank you very much, Prof, from Curtin University, Australia. Associate Professor Christopher M. Kaysen, thank you, Prof, for your coming from University of Washington. Assistant Professor Roslinda Muhammad Fadil, LLB ILM from University Kebangsaan Malaysia. Profesor Nur Barizah PhD from Universitas Erlangga. Profesor Dr. Igusti Ayu Ketut Rahmi Handayani from Universitas 11 Maret. And Profesor Dr. Ibnu Nugroho from Universitas Jenderal Sudirman. Thank you, Prof. And all the respected professors in the Faculty of Law, all the participants, the committee, and also the sponsors from IFG, from Bank Negara Indonesia, and Bank Jateng, to the third International Conference on Law, Governance, and Social Justice in 2023. Ladies and gentlemen, and distinguished guests, I'm honored to stand before you as the chairperson of International Conference on Law, Governance, and Social Justice. This conference marked our third gathering following successful events in 2019 and 2020. And in this international conference, our journey began in February 2023. And today, I'm pleased to report on the outcomes of our collective efforts to all of you. We have had the privilege of hosting 6 distinguished speakers, not only from Indonesia but also from international, and 1 keynote speaker, the Honorable Professor in Universitas Jenderal Sudirman, who have enlightened us with the insight into various facets of law, governance, social justice. Our speakers have come from esteemed institutions both nationally and internationally, and have covered topic ranging from the public law into the private law. This is very wide ranging, correlating with the law aspect. This conference has been monumental gathering with 146 presenters and over than 850 participants, not only Indonesia but also outside Indonesia, from Thailand, from India, from Malaysia also. Hailing into 33 universities that joined this conference. And the diversity and caliber of the attendance has made this event a melting pot of ideas and perspective. On this 3-day conference, I report that on the first day, we had a public lectures that held in the Faculty of Law by Bu Roslinda from UKM, and then visiting lecturer from Associate Professor Christopher. Thank you very much for the first day, and we have had the gala dinners. Very interesting events that we celebrate at night yesterday. And the second day, right now we have the main events, featuring 2 plenary sessions and 2 parallel sessions running from 9 to 9, 12 hours. We had the conference, and tomorrow we will have study excursions, or we have a city tour to the prison island, to Nusa Kambangan, offering a unique learning experience for our attendees. In this occasion, I would like to extend my heartfelt gratitude to everyone who has contributed to the success of this conference, especially for the committee. You are all the best. Thank you very much for the committee. And also for the sponsor and the participant. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
We thank the chairman of the ICOLGAS for the speech. Ladies and gentlemen, the next speech will be delivered by the Dean of the Faculty of Law, Jenderal Sudirman University. Dear Professor Dr. Muhammad Fauzan SHM, the floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Saya ulangi. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi. Alhamdulillahirrabbilalamin. Wassalatu wassalamu ala asrofil amil mursalin wa ala alihi wa sahbihi ajmain. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Yang saya hormati keynote speaker Prof. Dr. Sanitar Burhanuddin, Pak Jaksa Agung, ya, terima kasih atas kehadirannya, dan insya Allah pada masa yang akan datang beliau akan hadir secara luring ke Fakultas Hukum, insya Allah. Kemudian yang saya hormati Pak Rektor, Prof. Sodik, beserta para Wakil Rektor, Pak Dr. Kuat Puji Praitno, terima kasih atas kehadirannya. The Honorable Speaker, all speaker, Prof. Dora, kemudian Prof. Christopher, Prof. Ibnu Nugroho, kemudian Profesor Dr. I Gusti Ketut Ayu Rahmi Handayani yang hadir secara daring, kemudian Prof. Nurul Bazirah dari UNER, kemudian Profesor Roslinda, terima kasih atas kehadirannya. Yang saya hormati juga yang hadir secara daring, Bapak Ibu Kepala Kejaksaan Tinggi di seluruh Indonesia. Kemudian Bapak Ibu Kepala Kejaksaan Negeri di seluruh Indonesia. Dan yang saya hormati yang hadir secara luring, para kajari di Banyumas Raya, ya. Pak Kajari Purwokerto, Pak Kajari Banjarnegara, Pak Kajari Cilacap, Banyumas, ya, terima kasih atas kehadirannya. Ya. Kemudian yang saya hormati juga ada Sekjen KFA, ya. Kemudian saya hormati juga para Bapak Ibu dosen, guru besar Fakultas Hukum, para dekan, ketua lembaga, dan hadirin peserta seminar yang berbahagia. Pertama dan utama marilah kita panjatkan rasa syukur kehadirat Allah SWT yang telah melimpahkan rahmat, hidayah, dan inayahnya kepada kita semua, sehingga pada pagi yang cerah ini kita bisa berjumpa dalam forum ini, dalam majelis ini. Mudah-mudahan kehadiran kita bernilai ibadah di hadapan Allah Subhanahu wa Ta'ala. Sholawat dan salam juga mudah-mudahan tetap tercurahkan kepada junjungan kita Nabi Agung Muhammad Sallallahu Alaihi Wasallam. Bapak Ibu sekalian yang saya hormati, jadi tradisi seminar internasional atau yang sering kita sebut dengan ICOLGAS ini adalah merupakan sebuah tradisi yang sudah sekian kali dilaksanakan di Fakultas Hukum. Terlebih Fakultas Hukum itu sudah beberapa waktu yang lalu Pak Rektor, ya, sudah terakreditasi FIBA-A, ya. Mudah-mudahan tradisi ini akan terus berlanjut di masa-masa yang datang. Di periode ini ada, periode saya ada, kemudian nanti periode yang akan datang mudah-mudahan bisa dilaksanakan lagi. Ya. Kemudian yang kedua, Bapak Ibu sekalian yang saya hormati, atas nama pimpinan Fakultas Hukum sungguh mengucapkan banyak terima kasih yang tak terhingga atas kehadiran Bapak Ibu sekalian yang mulai dari tadi malam sudah semangat, ya, sampai sekarang kelihatannya insya Allah masih happy. Mudah-mudahan besok juga ketika kita akan ke Pulau Nusa Kambangan tetap sehat dan pulang bisa dengan banyak kesan-kesan yang baik dengan Fakultas Hukum Universitas Jenderal Sudirman. Bapak Ibu sekalian yang saya hormati, atas nama pimpinan juga, bila selama penyelenggaraan ICOLGAS yang saya yakin mudah-mudahan ini kesannya baik, tetapi bila ada hal-hal yang kurang berkenan di hati Bapak Ibu sekalian, sungguh saya atas nama pimpinan mohon maaf yang sebesar-besarnya. Demikian, terima kasih, selamat untuk mengikuti seminar dan nanti saya mohon untuk Pak Rektor berkenan untuk membuka secara resmi acara pada pagi hari ini. Terima kasih. Billahi taufik wa hidayah. Assalamualaikum warahmatullahi wabarakatuh.
We thank the Dean of the Faculty of Law of Jenderal Sudirman University for that speech. The last speech will be delivered by the Rector of Jenderal Sudirman University and to officially open the conference, the Honorable Professor Dr. Unsoed Ahmad Sodik, Master of Science, Agriculture, IPU. The floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, selamat pagi, salam sejahtera untuk kita semua. Salam Om Swastiastu, Namo Buddhaya, salam kebajikan, Rahayu. The Honorable Vice Rector Jenderal Sudirman University, the Dean and the Head of Institution Universitas Jenderal Sudirman, yang kami hormati, sama-sama kita hormati beliau Bapak Profesor Burhanuddin, Jaksa Agung Republik Indonesia, beserta seluruh jajaran para Kajari dan Kajati, baik yang hadir secara daring maupun secara luring. The Honorable Speaker, Professor Dora, welcome to Jenderal Sudirman University. I think this is the first time you come to Purwokerto. I hope enjoy in our university. Also, Professor Christopus, selamat datang. I know you fluent in bahasa Indonesia. Yang kami hormati Asisten Profesor Roslinda from University Kebangsaan, Profesor Nulul Barizah from University Airlangga, Profesor Gusti Ayu Ketut from 11 Maret University, Profesor Hipnu from Jenderal Sudirman University, and all the participants, the committee, and all the sponsorship on the third international seminar on law government and social justice. Alhamdulillah wa syukurillah la haula wa la quwata illa billah. First of all, I would like to extend the warm welcome to all speakers, presenters, and all participants in the third international conference, Law Government, Social Justice, hosted by Law Faculty, Jenderal Sudirman University. The success of our previous conference held in 2018 and 2020, fostering critical thinking and contributing to the global discourse on law government and social justice, remain unwavering. This conference is evidence of our commitment to having a significant influence both within our university and in the large international community. The challenges of law, government, and social justice are more important than ever in the current global environment. These are the pillars that support the development of countries and the welfare of the people. However, the implementation of justice and efficient government has difficulty due to the constantly shifting dynamic of the global political environment. Significant constitutional amendment have recently taken place in Indonesia within the goal of putting in place a system of check and balance. The executive, legislative, and judicial branch have now its taken on the different role as a result of the redistribution of role. This is a significant step in the direction on good governance. Local autonomy has its often unique set of difficulties at the local level. It gives local government more authority to better govern and administrate their neighborhood. But it also raises concern about how to successfully satisfy the wide range and need of our inhabited while pursuing social justice. Ladies and gentlemen, this conference purpose to discuss this little bit complicated issue through a multifaceted approach to enhance our understanding and knowledge of law, government, and social justice on international scale, to act as a discussion venue for scholarly discussion among academicians, practitioners, reviewers, educators in various subjects, to increase our collective knowledge and experience by gaining viewpoint and insight from legal and political specialists, to foster a collaborative atmosphere where ideas might be freely discussed among stakeholders, and the last, to provide practical insight that can direct policy and decision-making in the area of law, government, and social justice. We expect that this discussion in this forum will emerge in idea, plan, and action. Ladies and gentlemen, again, I would like to express our gratitude and congratulations to the entire committee speaker participant. Terima kasih atas perhatian. Good luck and enjoy with conference. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
To His Excellency, Prof. Sadiq to officially open the conference.
Dengan dua speaker. Prof. Dona and Christopher, please sit in. Iya, please. Bapak Ibu yang kami hormati, marilah dengan memanjatkan puja dan puji syukur kepada Allah Subhanahu wa taala. With name on Allah Subhanahu wa taala, Bismillahirrahmanirrahim. The third International Conference on Law, Government and Social Justice held by Faculty of Law, Universitas Jenderal Sudirman is officially open. Thank you very much.
Okay, ladies and gentlemen, the next agenda is photo session. For the first session, we'd like to invite the Rector of Jenderal Sudirman University,
To all
speakers.
To all ladies and gentlemen, please stay on stage because we are going to have another photo session with invited guests. I would also kindly invite the Vice Rector of Jenderal Sudirman University, the Vice Rector of Jenderal Sudirman University, and also the Dean of all faculties in Jenderal Sudirman University, and also invited speakers. Please kindly come forward to the stage to take a photo together. Please, ladies and gentlemen, to stay on stage for quite a while. And to all leaders of the committee, please come forward to the stage to take a photo session together.
Kami undang para pimpinan dalam panitia kepada Ibu Dr. Riris dan Ibu Aryuni untuk naik ke atas panggung. Selanjutnya kami undang juga seluruh tamu undangan.
To all invited guests, also please kindly come forward.
Kepada Bapak Ibu tamu undangan kami persilakan untuk maju ke atas panggung untuk foto bersama.
To ladies and gentlemen who are currently on stage, please step down to have a photo session again with all participants.
Kepada Bapak Ibu untuk tetap berdiri di depan panggung untuk foto bersama dengan seluruh peserta. Bapak Ibu tamu undangan, Wakil Rektor, Bapak Rektor dan juga Dekanat untuk tetap berdiri di depan untuk foto bersama dengan para tamu undangan. To all participants, would you please stand up for the next photo session? Dipersilakan kepada Bapak Ibu peserta untuk berdiri untuk foto bersama. Iya. To all participants, will you please stand up for the next photo session? To photo together with the speakers. Yeah.
To His Excellency Professor Dr. Sanitar Burhanuddin to also please turn on the camera, and also all participants who join with us online, please do open your camera and keep turning your camera on.
Silakan Bapak Ibu yang masih berada di belakang untuk bisa merapat ke depan untuk foto bersama. Ke tengah. Silakan Bapak Ibu bisa merapat. Bapak Ibu yang masih di belakang silakan dapat merapat ke depan untuk bisa foto bersama. Okay, thank you so much. Please visit it. Terima kasih Bapak Ibu, silahkan duduk kembali. Ladies and gentlemen, the next agenda is a keynote speech by the Honorable Attorney General of the Republic of Indonesia.
But before that, let me read his CV first. Professor Dr. Sanitar Burhanuddin is currently in charge as the Attorney General of the Republic of Indonesia. He received so many awards, one of which is Special Achievement Awards in 2022 from International Association of Prosecutors.
To present the speech, kindly invite the Honorable Professor Dr. Sanitar Burhanuddin, SH, MH.
maupun pemahaman yang mendalam terkait pemerintah dan keadilan sosial, termasuk di dalamnya perkembangan dunia internasional, semana tujuan dilaksanakan kegiatan usaha konferensi internasional yang saya banggakan. Secara konstitusional, Indonesia adalah negara hukum, sebagaimana ditegaskan di dalam pasal 1 ayat 3 Undang-Undang Dasar Negara Republik Indonesia tahun 1945. Adapun sistem pemerintahan yang dianut Indonesia dinyatakan secara eksplisit di dalam penjelasan Undang-Undang Dasar 1945, yaitu bahwa sistem pemerintahan negara Indonesia adalah negara berdasarkan hukum pesta, tidak berdasarkan kekuasaan atau mesta. Di dalam masyarakat yang berarti bahwa negara memberikan perlindungan hukum kepada masyarakatnya. Antara hukum dan kekuasaan ada hubungan timbal balik. Jika kita berbicara tentang negara hukum, maka kita akan bertolak pada cita-cita atau isne dan jenis yang mengubahkan bahwa semua kekuasaan negara bersumber pada hukum. Dan hukum tersebut didasarkan kepada nilai-nilai yang tinggi dari kemanusiaan yang bersifat pribadi manusia. Perbedaan mendasar mengenai konsepsi negara hukum yang dianut oleh Indonesia dengan konsep negara hukum pada umumnya pernah dikemukakan oleh Marjen Thermoseulis yang menjelaskan bahwa konsep negara hukum Indonesia berasal dari konsep Barat atau Restrat. Selama periode pertama setelah kemerdekaan Republik Indonesia tahun 1945 yang dipengaruhi oleh tipe Eropa daripada tipe Amerika. Hal ini disebabkan adanya konsekuensi dari hukum bekas kolonialisasi yang berlangsung lama dan berabad-abad pada pertengahan yang masih banyak berpengaruh Eropa daripada Amerika atau common law. Berdasarkan hal tersebut, maka hukum dilaksanakan dan ditaati. Pelaksananya penegakan hukum harus selalu menjunjung hak hidup, kebebasan, kemerdekaan, dan keamanan bagi individu. Karena hukum mempunyai tujuan untuk melindungi kepentingan manusia dan menciptakan ketertiban serta ketentraman masyarakat. Bapak, Ibu, dan para peserta sekalian, sebagai dua sisi mata uang, hukum dan pemerintahan adalah dua hal yang tidak dapat dipisahkan, karena memiliki hubungan timbal balik, di mana keduanya akan saling melengkapi dalam mencapai tujuan dari negara hukum itu sendiri. Secara esensial, negara hukum pada hakikatnya memiliki 4 unsur pokok, Yaitu yang pertama adalah pemerintah melaksanakan tugas dan kewajibannya harus berdasarkan atas hukum atau peraturan perundang-undangan. Yang kedua adalah jaminan terhadap penegakan dan pelaksanaan hak asasi manusia. Yang ketiga adalah adanya pembagian kekuasaan di dalam negara atau trias politika. Dan keempat adalah adanya pengawasan dari badan-badan peradilan. Hubungan antara hukum dan kekuasaan sebagaimana dikatakan oleh Mukhtar Kusumaatmadja, yaitu bahwa hukum tanpa kekuasaan adalah angan-angan. Dan kekuasaan tanpa hukum adalah kejaliman. Artinya, sebaik apapun hukum dibuat tidak akan bermanfaat jika tidak ditegakkan. Dan sekecil apapun kekuasaan yang dijalankan tanpa dilandasi oleh hukum adalah kesewenang-wenangan. Negara hukum yang sangat mengedepankan adanya supremasi hukum tidak membenarkan seorang pun termasuk pemegang kekuasaan sekalipun untuk melakukan tindak-tindakan yang tidak sesuai dengan aturan hukum atau menjalankan kekuasaan secara sewenang-wenang. Kekuasaan harus dijalankan sesuai dengan koridor hukum positif yang berlaku demi kemaslahatan. Kemaslahan masyarakat, bangsa, dan negara, bukan untuk kepentingan pribadi. Golongan kelompok tertentu atau justru kekuasaan malah digunakan untuk menindas masyarakat. Dan demikian hukum idealnya berperan sebagai legalitas atas seluruh aktivitas yang dilakukan pemerintah di dalam menjalankan kekuasaannya. Berdasarkan hubungan tersebut, maka hukum dan kekuasaan tidak dapat dipisahkan dalam satu proses pencapaian tujuan hukum itu sendiri, yaitu keadilan, kepastian, dan kemanfaatan. Para peserta seminar internasional yang berbahagia, keadilan merupakan salah satu tujuan hukum yang paling banyak dibicarakan sepanjang perjalanan sejarah filsafat hukum. Meski demikian, sebagaimana yang telah dijelaskan sebelumnya, hukum tidak hanya berusaha untuk mewujudkan keadilan, namun juga kepastian dan kemanfaatan atas pelaksanaan hukum itu sendiri. Sudah seharusnya hukum dapat mengakomodasi ketiga hal tersebut. Untuk itu, masyarakat mengharapkan bahwa aturan hukum atau kebijakan pemerintah yang dibuat dapat berpihak terhadap kepentingan umum dan ditegakkannya sebagaimana mestinya untuk mewujudkan tujuan utama dan mulia, yaitu keadilan sosial bagi seluruh masyarakat Indonesia. Keadilan merupakan tujuan akhir hukum. Oleh karena itu, keadilan di dalam kehidupan berbangsa dan negara ini adalah penting, baik terkait aspek sosial budaya, politik, dan pemerintahan maupun demi kepentingan penegakan hukum itu sendiri. Bapak, Ibu, serta hadirin sekalian yang berbahagia, hubungan hukum dan kekuasaan dapat juga dilihat dari proses pembentukan dan penegakan hukum dalam proses pembentukan hukum. Hukum merupakan cermin dari kekuasaan. Apabila kekuasaannya dijalankan dengan bersih dan beretika, maka hukum akan menjadi hukum yang adil dan beradab. Namun sebaliknya, apabila kekuasaan itu tuna etika, maka hukum tersebut akan jauh dari kata adil bagi masyarakat. Setidaknya terdapat 3 bentuk manifestasi hubungan hukum dan kekuasaan. Yaitu yang pertama, hukum tunduk pada kekuasaan, artinya hukum seringkali digunakan sebagai alat untuk kekuasaan. Hukum dalam hal ini ditempatkan di bawah kontrol kekuasaan. Kedua, kekuasaan tunduk pada hukum, artinya kekuasaan harus berada di bawah hukum, dan hukum yang menentukan eksistensi kekuasaan. Pandangan ini yang menjadi dasar konsep terminologi supremasi hukum. Ketiga, adanya hubungan timbal balik antara hukum dan kekuasaan. Dalam hal ini, hubungan hukum dan kekuasaan tidak bersifat dominan satu dengan yang lainnya, melainkan bersifat fungsional, yaitu kekuasaan memiliki fungsi terhadap hukum, dan sebaliknya, hukum mempunyai fungsi terhadap kekuasaan. Dalam menjalankan kekuasaannya, negara membentuk alat-alat atau organ untuk menyelenggarakan ketertiban, keamanan, serta penegakan hukum yang dilaksanakan oleh aparatur penegak hukum. Aparatur penegak hukum ini diberi tanggung jawab untuk menindak siapapun demi terwujudnya keselarasan dan kedamaian di dalam masyarakat. Sebagai bentuk realisasi keadilan. Keadilan sosial dalam kehidupan bermasyarakat, berbangsa, dan negara. Hadirin yang saya banggakan. Sejalan dengan konsep hukum negara yang dianut Indonesia, maka kekuasaan negara di bidang kehakiman harus dilaksanakan secara merdeka untuk menjalankan peradilan guna menegakkan hukum dan keadilan berdasarkan Pancasila dan Undang-Undang Dasar 1945. Kekuasaan untuk menegakkan hukum oleh negara didistribusikan kepada institusi-institusi yang formal yang melaksanakan fungsi penegakan hukum. Berbicara mengenai sistem penegakan hukum, artinya penegakan hukum pidana, hal ini bersentuhan langsung dengan sistem peradilan pidana yang secara ide dan filosofisnya, peradilan pidana bertujuan untuk menegakkan ketertiban, kebenaran, dan keadilan. Pak Al menjelaskan, sistem peradilan pidana, criminal justice, adalah satu sistem berprosesnya suatu peradilan. Masing-masing komponen fungsi yang terdiri dari kepolisian sebagai penyidik, kejaksaan sebagai penuntut umum, dan pengadilan sebagai pihak yang mengadili, dan lembaga pemasyarakatan yang berfungsi untuk memasyarakatkan kembali para terhukum yang bekerja secara bersama-sama terpadu dalam usaha untuk mencapai tujuan bersama, yaitu untuk menanggulangi kejahatan. Ingat, menanggulangi kejahatan, walaupun kekuasaan itu adalah hukum. Namun kekuasaan tidak identik dengan hukum. Mengenai ini, Pak Napeldon mengupakan bahwa hukum adalah kekuasaan, akan tetapi tidak berarti bahwa hukum tidak lain daripada kekuasaan belaka. Hukum adalah kekuasaan, akan tetapi kekuasaan tidak selamanya hukum. Kekuasaan di dalam konteks hukum meliputi kedaulatan, wewenang, otoritas, dan hak. Ketiga bentuk kekuasaan itu memiliki esensi dan ciri-ciri yang berbeda suatu sama lainnya dan bersifat hierarkis yang tersusun secara berjenjang. Kekuasaan tertinggi adalah kedaulatan, yaitu kekuasaan negara secara definitif untuk memastikan aturan kelakuan di dalam wilayahnya, dan tidak ada pihak baik di dalam maupun di luar negeri yang harus diminta izin untuk menetapkan atau melakukan sesuatu. Kedaulatan adalah hak kekuasaan mutlak, tertinggi, tak terbatas, tak tergantung, dan tanpa kecuali. Hadirin yang berbahagia, dalam menjalankan kekuasaan negara dalam konteks hukum, dibutuhkan kedaulatan. Kedaulatan adalah ciri atau atribut hukum dari negara-negara, dan sebagai atribut negara, dia sudah lama. Dan bahkan ada yang berpendapat bahwa kedaulatan itu mungkin lebih tua dari konsep negara itu sendiri. Dalam teori kenegaraan, ada 4 bentuk kedaulatan sebagai pencerminan kekuasaan tertinggi di dalam satu negara. Keempat bentuk kedaulatan adalah kedaulatan Tuhan, kedaulatan negara, kedaulatan hukum, dan kedaulatan rakyat. Dari situ dapat kita lihat bersama rangkaian keterkaitan suatu sama lainnya mengenai bagaimana negara menjalankan tugasnya dengan kedaulatan untuk menjalankan sistem hukum pada negara. Keterkaitan hukum dengan kekuasaan yang lain adalah untuk mengatur dan membatasi kekuasaan itu sendiri. Dengan demikian, pendistribusian kewenangan dalam bidang hukum tertentu harus disinkronkan dengan pengaturan wewenang dalam bidang hukum lainnya. Pembatasan kekuasaan dapat dilakukan secara sistemis, organik, dan yuridis. Pembatasan kekuasaan dimaksudkan untuk menghindari terjadinya penumpukan atau sentralisasi kekuasaan pada suatu tangan atau pada suatu lembaga. Sentralisasi kekuasaan akan mendorong kepada otoritarisme dan menyelenggarakan negara dan penyalahgunaan kekuasaan. Bapak Ibu yang saya hormati, dalam rangka meningkatkan kualitas penyelenggaraan pemerintahan serta untuk mengupayakan kesejahteraan umum dan pejabat pemerintah di dalam menggunakan wewenangnya harus mengacu pada ajas-ajas umum pemerintahan yang baik dan didasarkan ketentuan peraturan perundang-undangan. Dalam sistem pemerintahan yang dianut Indonesia, maksud dari ajas-ajas umum pemerintahan yang baik secara tegas dinyatakan di dalam Pasal 1 Angka 17 Undang-Undang Nomor 30 Tahun 2014 tentang Administrasi Pemerintahan adalah prinsip yang digunakan sebagai acuan menggunakan wewenang bagi pejabat pemerintah dalam mengeluarkan suatu keputusan dan atau tindakan dalam menjalankan pemerintahan. Rumusan ajas umum pemerintahan yang baik dapat ditemukan di dalam norma pasal 10 Undang-Undang Nomor 30 Tahun 2014 tentang administrasi pemerintahan. Pasal tersebut menyatakan bahwa ajas umum pemerintahan yang baik meliputi ajas kepastian hukum, ajas ketidakberpihakan, ajas kemanfaatan, ajas kecermatan, Ajas tidak menyalahgunakan kewenangan, ajas keterbukaan, ajas kepentingan umum, dan ajas pelayanan yang baik. Kemudian selain ajas-ajas itu juga dapat diterapkan ajas-ajas lain sepanjang dijadikan dasar penilaian hakim yang tertuang di dalam putusan pengadilan yang berkekuatan hukum tetap. Ajas umum pemerintahan yang baik berlaku bagi semua lembaga-lembaga dan badan-badan negara yang ada di Indonesia. Ajas ini tidak hanya dikaitkan dengan kekuasaan pemerintahan, eksekutif yang dijalankan oleh alat administrasi negara, akan tetapi juga diberlakukan untuk cabang-cabang kekuasaan lainnya seperti pembentuk undang-undang, legislatif, dan kekuasaan penegakan hukum atau yudikatif. Bahkan untuk semua badan-badan negara yang ada, pemerintahan yang memangku kewenangan eksekutif di dalam menjalankan kewajibannya selaku pelayanan publik harus memperhatikan ajas-ajas umum pemerintahan yang baik agar tidak menjalani aturan dan prosedur-prosedur dalam pelaksanaan kewenangannya. Bagi penyelenggara pemerintah di bidang legislatif, ajas-ajas umum pemerintahan yang baik juga diperlukan sebagai patokan dan arahan dalam pembuatan peraturan perundang-undangan. Lebih lanjut, bagi aparat pemerintahan di bidang yudikatif, ajas-ajas umum pemerintahan yang baik diperlukan sebagai dasar pengujian oleh hakim terhadap keputusan tata usaha atau terhadap gugatan yang diajukan oleh seseorang atau badan hukum perdata di pengadilan. Pada dasarnya, penyelenggaraan pemerintah mengemban 3 fungsi hakiki, yaitu pelayanan atau servis, pemberdayaan, dan pembangunan atau development. Dengan demikian, setiap kebijakan yang dibuat oleh administrasi negara, seyogyanya di samping memperhatikan ajas legalitas, juga harus memperhatikan aspek hierarkis hukum dan hukum kebiasaan atau aspek moralitas. Pada aspek terakhir inilah ajas-ajas umum pemerintahan yang baik berfungsi sebagai salah satu dasar pertimbangan bagi administrasi negara dalam mengeluarkan kebijakannya. Sebab itu tidak akan menjadi senjata makan tuan. Artinya kebijakan yang menafikan ajas-ajas umum penyelenggaraan pemerintahan yang layak atau AAUPL, justru AAUPL berbalik menjadi alat uji untuk membatalkan kebijakan tersebut. Bapak Ibu yang saya hormati, lebih lanjut mengenai penerapan ajas-ajas umum pemerintahan yang baik, salah satu ajas yang dianggap sangat penting adalah ajas kepastian hukum. Hal ini dikarenakan banyak pakar memasukkan ajas kepastian hukum sebagai prinsip penting di dalam menilai aspek material atau isi dari keputusan penyelenggara pemerintahan. Kepastian sendiri tersebut sebagai salah satu tujuan hukum, di mana hukum yang menjamin kepastian hukum yang adil. Substansinya harus dan wajib mencerminkan nilai-nilai kemasyarakatan. Oleh karena hukum itu merupakan pencerminan belaka dari masyarakatnya, yaitu gagasan-gagasan, tradisi, nilai-nilai, dan tujuan-tujuan yang ada di dalam masyarakat tersebut. Debut dan Condon menyatakan kehadiran hukum sebagai skema perjalanan seiring dengan semakin kuatnya citra kemasyarakatan sebagai suatu kehidupan yang distruktur dan dikonstruksikan. Ajas-ajas kepastian hukum menjadi fundamental karena setiap perbuatan yang berkaitan dengan tindakan hukum, maka aparat penegak hukum wajib meninjau keseluruhan nilai-nilai kebenaran dan keadilan, harus menjamin nilai kepastian hukum. Ajas lain yang juga penting adalah konteks keadilan sosial, adalah ajas ketidakberpihakan, tidak diskriminatif. Ajas ini dijelaskan dalam Undang-Undang Administrasi Pemerintahan, memberikan pemahaman bahwa setiap badan atau pejabat pemerintahan di dalam membuat keputusan atau tindakan wajib mempertimbangkan kepentingan para pihak secara keseluruhan dan wajib bersikap dan bertindak adil dan tidak diskriminatif. Negara atau pemerintah tidak boleh bersikap diskriminatif atas dasar apapun, karena itu negara dituntut adil dan proporsional dalam menjalankan pemerintahan sesuai dengan peraturan perundang-undangan yang menjadi landasan. Sehingga ajas ini konsisten dan sejalan dengan tuntutan pasal 27 Undang-Undang Dasar Negara Republik Indonesia tahun 1945 yang memberikan kedudukan yang sama kepada semua warga negara di depan hukum dan pemerintahan. Dari uraian yang telah dijelaskan, dapat ditarik suatu kesimpulan bahwa ajas ini memberikan pedoman bagi aparatur pemerintah di dalam perbuatannya dan berakibat hukum agar menempatkan dirinya sebagai subjek hukum yang sama kedudukannya dengan pihak lain. Bapak Ibu peserta konferensi internasional yang saya muliakan, Pancasila telah menjadi landasan ideal bangsa ini, sekaligus menjadi dasar negara Republik Indonesia, baik di dalam arti sebagai dasar ideologi maupun filosofi bangsa. Pancasila sebagai ideologi bangsa artinya setiap warga negara Republik Indonesia terikat oleh ketentuan-ketentuan yang sangat mendasar yang tertuang di dalam sila yang kelima. Kadang-kadang kedua istilah tersebut disatukan menjadi Pancasila sebagai ideologi bangsa dan negara Indonesia. Kemudian Pancasila merupakan sebagai sumber dari segala sumber hukum negara. Diangkat dari nilai-nilai adat istiadat, nilai-nilai kebudayaan, serta nilai-nilai religius yang terdapat di dalamnya. Pandangan hidup masyarakat Indonesia sebelum membentuk negara, sehingga setiap materi perbuatan kebijakan negara tidak boleh bertentangan dengan nilai-nilai yang terkandung di dalam Pancasila. Dengan kata lain, kedudukan Pancasila di dalam sistem hukum Indonesia merupakan sumber dari segala sumber hukum atau sumber tertib hukum. Sehingga Pancasila dijadikan nilai-nilai dasar bagi penyusunan norma hukum Pancasila. Merupakan suatu sistem, karena keterkaitan antara sila-silanya menjadikan Pancasila sebagai suatu kesatuan yang utuh. Pengalaman yang baik dari satu sila sekaligus juga harus diamankan dengan sebaik-baiknya antara sila-sila dengan yang lainnya. Dengan ditetapkan Pancasila sebagai dasar negara, maka Pancasila juga menjadi etika sosial yang berarti seperangkat nilai-nilai yang secara terpadu harus diwujudkan dalam kehidupan berbangsa dan bernegara. Etika sosial tersebut mencangkup aspek sosial, budaya, politik, pemerintahan, ekonomi, bisnis, penegakan hukum yang berkeadilan, keilmuan, serta lingkungan. Nilai keadilan termaktub dalam sila kelima. Pancasila yaitu keadilan sosial bagi seluruh rakyat Indonesia. Hal ini mengandung makna bahwa dasar sekaligus tujuan pemerintahan yang semata-mata tercapainya masyarakat Indonesia yang adil dan makmur secara lahiriah maupun batinnya. Lebih lanjut, nilai yang terkandung di dalam sila keadilan sosial bagi seluruh rakyat Indonesia didasarkan dan dijiwai oleh sila-sila pertama sampai dengan sila yang keempat. Di dalam sila yang kelima terkandung nilai-nilai merupakan tujuan negara sebagai tujuan dalam kehidupan bersama. Maka di dalam sila yang kelima tersebut terkandung nilai keadilan yang harus terwujud di dalam kehidupan bersama atau kehidupan sosial. Keadilan tersebut didasarkan adalah dijiwai juga oleh hakikat keadilan dalam hubungan manusia dengan dirinya sendiri, manusia dengan manusia lain, manusia dengan masyarakat, bangsa, dan negaranya, serta hubungan manusia dengan Tuhannya. Yudi Latif menegaskan bahwa sila kelima merupakan perwujudan yang paling konkret dari prinsip-prinsip Pancasila. Satu-satunya sila Pancasila yang dilukiskan di dalam pembukaan Undang-Undang tahun 1945 dengan menggunakan kata dasar mewujudkan suatu keadilan sosial bagi seluruh rakyat Indonesia. Peserta konferensi internasional yang budiman, keadilan dan keadilan sosial memiliki sejarah pemikiran yang panjang dalam diskursus hukum dan negara. Negara merupakan figur sentral dalam mewujudkan keadilan dan keadilan sosial. Konsep keadilan sosial berbeda dari ide keadilan hukum, keadilan politik, keadilan ekonomi, keadilan individual, dan sebagainya. Tetap konsep keadilan sosial tentu juga tidak hanya menyangkut persoalan moralitas dalam kehidupan bermasyarakat yang berbeda-beda dari satu kebudayaan lain. Namun keseluruhan ide tentang keadilan itu pada akhirnya dapat dicangkup oleh berujung pada ide keadilan sosial. Jika saya boleh meminjam istilah Burton, keadilan sosial merupakan cita-cita yang bisa dihampiri semakin dekat, tapi tidak pernah direalisasikan dan sempurna. Dan cita-cita keadilan sosial merupakan cita-cita kita bersama yang perlu kita dorong dan berbagai pihak untuk mengusahakan konsep keadilan sosial merupakan simpul dari semua dimensi dan aspek kemanusiaan tentang keadilan, di mana hal tersebut erat kaitannya dengan pembentukan struktur kehidupan masyarakat yang didasarkan atas prinsip kesamaan. Hadirin forum ilmiah yang saya muliakan, berbicara mengenai keadilan suatu hal yang menarik dan perlu dikaji dan dicermati karena keadilan merupakan tujuan akhir hukum. Oleh karena itu, keadilan di dalam kehidupan berbangsa dan bernegara ini adalah sangat penting, baik terkait aspek sosial, budaya, politik, pemerintahan maupun demi kepentingan penegakan hukum itu sendiri. Keadilan terkadang suatu yang dipersepsikan berbeda oleh setiap orang. Misalnya dalam rangka perkara pidana yang acap kali terjadi ketika pengadilan memutus, memvonis terdakwa dalam suatu perkara persidangan dengan melalui pertimbangan-pertimbangan yang berdasarkan pada analisa yuridis dan fakta hukum di persidangan. Hukum yang dijatuhkan tersebut dinilai adil, namun bagi terdakwa, pengacara, dan keluarganya, hukum yang dijatuhkan tersebut bertentangan dengan keadilan. Sehingga benarlah bahwa keadilan itu sangat sumir dan sulit untuk dipahami bagi setiap orang. Saya berpandangan bahwa keadilan itu tidak ada dalam buku, namun tumbuh dari setiap insan dari masing-masing yang parameternya adalah hati nurani. Apakah yang dilakukan tersebut sesuai atau bertentangan dengan hati nurani? Untuk diketahui, keadilan menurut Reinhold Gregorius terbagi atas 5 bentuk, yaitu keadilan. Yang pertama adalah keadilan komunitatif. Adalah keadilan yang timbal balik yang terjadi ketika warga masyarakat melakukan transaksi kontraktual. Keadilan terjadi pada saat pemulihan dari keadaan cedera hak. Yang kedua adalah keadilan distributif, yaitu keadilan dalam pembagian keadilan distributif. Ini juga relevan dalam rangka keadilan sosial. Ketiga, keadilan pidana yang dijadikan dasar dan tujuan pengenaan hukuman pidana. Salah satunya ajas nulla cuna sine lege propria punali, yang berarti tidak ada delik, tidak ada pidana tanpa peraturan terlebih dahulu. Yang keempat adalah keadilan hukum acara yang ditentukan oleh kesempatan yang sama bagi sebuah pihak untuk menegaskan posisinya dan hakim yang tidak berat sebelah. Yang kelima adalah keadilan konstitusional berkaitan dengan penentuan syarat-syarat pemangkuan jabatan kenegaraan, misalnya di dalam pemilu. Hadirin yang saya hormati, dalam perkembangan proses penegakan hukum, masyarakat kecil sering kesulitan dalam mendapatkan akses keadilan hukum. Hukum saat ini masih mengedepankan aspek kepastian hukum, legalitas, formal, daripada keadilan hukum yang lebih substansial. Saat ini, publik menginginkan penegakan hukum yang tidak selalu kaku dan saklek dengan bunyi peraturan perundang-undangan, tetapi lebih kepada hukum yang mengalir. Menjawab tantangan tersebut, kejaksaan sebagai bagian dari sistem peradilan pidana saat ini telah bertransformasi menjadi institusi penegak hukum yang lebih progresif di dalam penanganan perkara, terutama perkara pidana, dalam rangka mewujudkan keadilan di tengah masyarakat. Kebijakan perubahan tersebut terwujud dengan penerapan konsep keadilan restoratif, sebagaimana di dalam Peraturan Kejaksaan Nomor 15 Tahun 2020 tentang penghentian penuntutan berdasarkan keadilan restoratif. Keadilan restoratif atau restorative justice adalah suatu pendekatan terhadap keadilan atas dasar falsafah dan nilai-nilai tanggung jawab, keterbukaan, kepercayaan, harapan, dan penyembuhan, inclusiveness, berdampak terhadap pengambilan keputusan kebijakan sistem peradilan pidana dan praktisi hukum di seluruh dunia, dan menjadikan hal yang positif ke depan berupa sistem keadilan untuk mengatasi konflik akibat kejahatan serta hukum yang dapat dipertanggungjawabkan, serta keadilan restoratif dapat terlaksana apabila fokus perhatian diarahkan pada kerugian akibat tindak pidana, keprihatinan yang sama dan komitmen untuk yang sama untuk melibatkan pelaku dan korban, mendorong pelaku untuk bertanggung jawab, kesempatan untuk dialog antara pelaku dan korban, melibatkan masyarakat berdampak kejahatan dalam proses relatif, mendorong kerjasama dan terintegrasi. Hadirin forum ilmiah yang saya hormati, relatif justice merupakan reaksi terhadap teori distributif yang berorientasi pada pembalasan dan teori neoklasik yang berorientasi kepada kesetaraan sanksi pidana dan sanksi tindakan. Dalam teori distributif, sanksi pidana bersumber pada ide mengapa diadakan pemidanaan. Dalam hal ini, sanksi pidana lebih menekankan pada unsur pembalasan yang sesungguhnya bersifat reaktif terhadap suatu perbuatan Ia merupakan penderitaan yang sengaja dibebankan kepada seorang pelanggar atau seperti yang dikatakan oleh John Kerr bahwa sanksi pidana dititik beratkan pada pidana yang diterapkan untuk kejahatan yang dilakukan. Sementara sanksi tindakan bersumber pada ide untuk apa diadakan pemidanaan. Jika dalam teori retributif sanksi pidana tertuju pada perbuatan salah seorang lewat pengenaan penderitaan, agar yang bersangkutan menjadi jera, maka sanksi tindakan terarah pada upaya memberi pertolongan agar ia berubah. Sanksi tindakan bertujuan lebih bersifat mendidik, berorientasi pada perlindungan masyarakat. Penyelesaian perkara pidana dengan pendekatan restoratif justice sangat relevan digaungkan saat ini, mengingat metode penyelesaian dan pendekatan restoratif justice menghasilkan 3 prinsip utama yang menjadi sasaran, yakni antara lain terjadi pemulihan kepada mereka yang menderita kerugian akibat kejahatan pelaku memiliki kesempatan yang terlibat dalam pemulihan keadaan restorasi. Pengadilan berperan untuk menjaga ketertiban umum dan masyarakat berperan untuk melestarikan perdamaian yang adil. Penegakan hukum berdasarkan keadilan restoratif tidak hanya mengejar kepastian hukum, menerapkan pasal-pasal yang kaku dan eksklusif, melainkan juga lebih mementingkan bagaimana penegakan hukum mampu melahirkan keadilan hukum yang lebih substansial dan eksklusif, tidak sekedar yang bersifat logistik, proseduralistik. Pada prinsipnya, keadilan relatif adalah suatu cara merespon penyelesaian perkara tindak pidana ringan yang selama ini hanya melalui pengadilan. Penyelesaian perkara pidana melalui keadilan restoratif menentukan pemulihan kembali kepada keadilan semula dan keseimbangan perlindungan antara kepentingan korban dan pelaku tindak pidana. Merupakan suatu kebutuhan hukum masyarakat yang diperlukan dalam pembaharuan sistem peradilan pidana. Jika perlu dipahami filosofi keadilan restoratif hadir sebagai terobosan hukum untuk memperbaiki citra dan mindset negatif penegakan hukum yang selama ini berkembang di masyarakat, bahwa hukum tajam ke bawah namun tumpul ke atas. Akan tetapi kita ubah pola pikir sebut dengan hukuman itu harus tajam ke atas dan humanis ke bawah. Forum ilmiah yang saya muliakan, sebelum mengakhiri pemaparan pada kesempatan ini, saya mengajak kita semua untuk saling bersinergi, bekerjasama, dan berkolaborasi, mengingat perguruan tinggi sebagai agen perubahan memiliki peran yang sangat strategis untuk mendorong arah perubahan pembangunan hukum nasional demi kemaslahatan kehidupan berbangsa dan bernegara. Semoga kegiatan konferensi internasional yang diprakarsai oleh Fakultas Hukum Universitas Jenderal Sudirman seperti ini dapat diselenggarakan secara berkelanjutan untuk memberikan sumbangsi yang nyata melalui berbagai pemikiran-pemikiran dari kalangan akademisi, praktisi maupun unsur masyarakat guna memperkaya khasanah ilmu hukum sekaligus demi mewujudkan penegak hukum yang lebih baik lagi. Para konferensi internasional dan hadirin yang saya banggakan, demikianlah beberapa hal yang dapat saya sampaikan. Semoga Allah Subhanahu wa Ta'ala, Tuhan Yang Maha Esa, senantiasa memberikan kekuatan, bimbingan, dan perlindungan kepada kita semua untuk senantiasa dapat memberikan kerja dan karya nyata yang terbaik bagi masyarakat, bangsa, dan negara. Sekian dan terima kasih. Wassalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semua. Om Santi Santati Om. Namo Buddhaya. Salam kebajikan.
Honorable Attorney General of the Republic of Indonesia for this speech.
Ladies and gentlemen, now we have come to the next agenda, plenary session 1, which Mr. Handityo Basworo, SHMH, will moderate.
But before that, let me read his short bio first. Mr. Handityo Basworo, SHMH, did his bachelor and also master degree at the Faculty of Law of Jenderal Sudirman University, and he is currently a lecturer at the Faculty of Law of Jenderal Sudirman University, and in his expertise in international law and also commercial law.
To Mr. Handityo, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Greetings to all the distinguished guests and participants of international conference who attends this conference both offline and online. May the grace and bless from the Almighty always bestow upon us. I am Handityo. I will be your moderator for this plenary session. To begin with, I will invite our speakers for this session. Our first speaker is Professor Roslina Muhammad Fazil from University Kebangsaan Malaysia. Please give her a warm welcome. For our second speaker, our esteemed professor, our Professor Dora Marinova from Curtin University. Please come stage, Professor. Our third speaker, one of our prominent professor and our celebrity professor, Professor Hipnu Nugroho from Jenderal Sudirman University. Please come upstairs, Professor. Good morning, Professor. It's been a privilege and an honor for me to be here with all of you. Before we begin, I would like to read first the curriculum vitae for each one of the speaker. We will be moving to the presentation for each one of the speaker. For our first speaker is Professor Roslinda Muhammad Fazil. She finished her study at Liverpool, and her research field is tort law, contract law, maritime law, human rights, land law, trade and financial law. The title of her presentation today is Sustainable Development Goal and Legal Challenges Relying on International Instruments of Human Rights Pertinent to Water Towards Malaysia SDG Compliance. And for our next speaker is her curriculum vitae. Professor Dora Marinova finished her school at Bulgaria, and her field of expertise is in the sustainability. The title of her paper today is Climate Change and the Human Right to a Clean, Healthy and Sustainable Environment. To our third speaker, Professor Hipnu Nugroho. He finished his study at University of Jenderal Sudirman, at University of Indonesia, and he finished his doctorate program in Diponegoro University. His field of expertise is in criminal justice system, criminalistic, and the restorative justice. The title of his paper today is Suprema Lex Esto Principle and its Implementation. For this session, Prof. Rosina will go first, and every single one of you will have 20 minutes to presenting your paper, and then we moving to Q&A session. Every single one of you. I think it's okay if you want to use the podium, or you will present in here. Yes, we'll show it at the place, Professor Rosina.
Bismillahirrahmanirrahim. Thank you so much, Bapak Moderator. Assalamualaikum warahmatullahi wabarakatuh. Dan salam sejahtera. Dan salam satu Malaysia. Good morning, ladies and gentlemen. Firstly, we praise Allah Subhanahu wa Ta'ala. As syukur, alhamdulillah, we can gather here in this hall together to discuss the third ICOLGAS. Honorable Professor Dr. Muhammad Fauzan, the Dean of the Faculty of Law, and all the Vice Deans, guru besar, lecturers, staff of Unsoed. Thank you so much for giving me opportunity to stand here today and discuss a topic that is dear to my heart. I am very happy to be in Purwokerto. My deepest gratitude also goes to two very special ladies and a gentleman. Nona Manis, Fatia Nisa, Ibu Aryuni dan Bapak Salman. To you I pray Allah give you long health, wealth and happiness. Inshallah, I wish also the same to all the participants here. Amin. Also to my fellow plenary speakers, I am in awe of you. I also would like to thank the students and organizing committee and show them my deepest gratitude, without which I deeply appreciate their skills in organizing this conference today. Today, my topic calls upon all of us to look at how human rights can, the slides are there, how human rights can help us realize our dreams, on how we can give our grandkids a safer dream by fulfilling the 17 Sustainable Development Goals, SDG in short form, as outlined in the United Nations Global Goals. In 2015, all United Nations members signed this treaty. Sebelum itu, saya minta maaf sekiranya di masa presentasi saya ada kekurangan. Yang baik itu semua dari Allah Subhanahu Wa Taala dan yang buruk itu daripada saya sendiri. So, for the SDG, it all started in 1992 in Rio de Janeiro. At the Agenda 21 conference, a few sustainable development goals had been thought out as a finding of that conference. As a result, the name Agenda 21 of these sustainable challenges had changed a few times. In the end, currently, in 2000, as of January 1st, 2016, the 17 Sustainable Development Goals of the 2030 Agenda for Sustainable Development were adopted by world leaders in September at a historic UN summit, and it officially came into force that year. The SDG built on the success of the Millennium Development Goals and aims to go further to end all kinds of poverty. There are 17 goals altogether. Firstly, no poverty. Number 2, zero hunger. Number 3, good health and well-being. Number 4, quality education. Number 5, gender equality. Number 6, clean water and sanitation. Number 7, affordable and clean energy. Number 8, decent work and economic growth. Number 9, industry, innovation and infrastructure. Number 10, reduce inequalities. Number 11, sustainable cities and communities. Number 12, responsible consumption and production. Number 13, climate action. Number 14, life below water. Number 15, life on land. That includes all of us. And number 16, peace, justice, and strong institutions. Number 17, partnership for the goals. This is the People's Agenda, a plan of action for ending poverty in all its dimensions, irreversibly everywhere and leaving no one behind. This was stated by Ban Ki-moon, the previous United Nations Secretary General. The UNDP Administrator Helen Clark, meanwhile, stated, "This agreement marks an important milestone in putting our world on an inclusive and sustainable course. If we work together, we have the chance of meeting citizens' aspirations for peace, prosperity, and well-being, and to preserve our planet. Preservation is the utmost importance, so that we can leave our future generations a clean and viable planet. To achieve the success of SDG depends highly on these 17 themes. My paper underlines SDG because as of 2015, the efforts that governments put into SDG are many, but not every one of those efforts are fruitful. So one of my suggestions is to look at the human rights instruments in order to help realize our dreams in 2030. Okay. And I will look into Malaysia's legislation and case laws as in Malaysia's, what is Malaysia's current effort in order to create successfully the goals of SDG. One of those is the Environmental Quality Act, which was an international treaty that was adopted into our local law. Ladies and gentlemen, humans need water. Human beings are composed mostly of it and cannot live for more than a few days without it. It seems almost inevitable, therefore, that there should be a human rights to water. According to the World Health Organization, indeed, it is not uncommon to encounter references to human rights to water. However, the instruments that would later be giving legal force to it does not have teeth to grip and enforcement to the question at hand. But while a case can certainly be made for such a right, it is not explicitly recognized in any of the instruments comprising the International Bill of Human Rights, notably the UDHR, Universal Declaration of Human Rights, and the two human rights treaties of 1966 that grew out of the Universal Declaration, the International Covenants of Civil and Political Rights, CP Covenant in short form, and on Economic, Social and Cultural Rights, ESC Covenant. As with water, humans as with air that we breathe, humans may not be deprived of water. The fact that water is not mentioned in the International Bill of Human Rights does not mean that humans do not have a right to it. In fact, the United Nations Committee on the Economic, Social and Cultural Rights, the body monitoring implementation rights to water, exists as an independent right by necessary implication from Article 11 and 12 of the Covenant. It may take some time for countries to respond, to have evidence on which to base a judgment as to whether an autonomous human rights to water truly forms part of international law. In any event, without water, as I personally feel, as a lecturer, when we speak a lot, we tend to be thirsty, right? We need supply of water sufficiently. The right is guaranteed in Article 12 of the ESC Covenant. Another possibility, next slide please. Another possibility that a human right to water is already part of customary international law, independent of the covenant, is not considered. As indicated, no such right is mentioned in the Universal Declaration, which is often said to be largely reflective of customary law. In addition, it is difficult to identify evidence of state practice on which to base such a customary right to water. Yet it is entirely possible that the action of the ESC Committee in adopting General Comment number 15, as stated in the Universal Declaration, will attract sufficient state practice over time that a customary norm will be formed on courts of justice, and they have said that it is a perfectly possible one and does from time to time occur. This was stated in the case of North Sea Continental Shelf, case FR 1969 ICJ at paragraph 71. None of the general human rights instruments provides expressively for human rights to water. The 1948 UDHR proclaims Article 25 that everybody has the right to a standard living, adequate for the health and well-being of himself and his family, including food. The word including indicates that the list of items in the article is not exhaustive. It's obvious that water, even more than food, is essential to health and well-being. It should therefore be taken to be included by necessary implication. Even though lack of adequate necessary directly or indirectly phrase the verb to produce much more of food we eat, the process of which include water. Since the right to an adequate standard of living falls into the latter category, it is uncertain whether it can be considered to be protected by the norm of customary international law. Ladies and gentlemen, the two covenants, the 1966 covenant, in treaty form upon provisions of the UDHR, in some cases added rights, and difference between the covenants is that parties have an immediate obligation to respect and ensure. So they must allow for the strict application of the 1966 covenant only to signatories and ratifiers, of course. Next slide, please. So we've covered the sources of human rights, which is the Universal Declaration, the two covenants. So lastly, we look at other instruments the legal instruments, while human rights to water must be inferred from the general human rights instruments, an obligation to provide an adequate domestic drinking water supply is expressly provided for in several human rights and humanitarian treaties of a more specialized character, as seen in the 1989 Convention on the Rights of the Child, the 1979 Convention on the Elimination of All Forms of Discrimination Against Women. This is seen in General Assembly Resolution 25 and 34 respectively. However, none of these agreements cast the corresponding entitlement in human rights terms. Instead, they place a responsibility on governments to ensure that water, among other things required to life and good health, is provided to members of groups that have been identified as requiring special protection. So in Malaysia, for example, we have 3 classes of wealth: the upper class, the middle class, and those who need help, that is called the B40 class. So it's like the dole system of the United Kingdom. They get some help from the government and also some help from their respective states where they come from, according as to Sharia law. Sepertinya siapa yang membayar zakat, dari duit zakat itu diberikan kepada fakir-fakir ini dalam kategori B40. More local law as seen at the European Parliament level. They declared in September 2003 that access to drinking water is a basic human right. And the European Council on Environmental Law has adopted a resolution on the acknowledgement of the right to drinking water in the member states of the European Union. These are positive steps that bolster human rights to water in the context of Europe. Next, we look at the general comment and its implications. Next slide, please. At its 29th session in 2002, the United Nations Committee on Economic, Social and Cultural Rights, ESC Committee, adopted General Comment number 15 on the rights to water, as seen in Articles 11 and 12 of the International Covenant of Economic, Social and Cultural Rights. Some of the main features of the General Comment 15 includes the following. Water here must be declared a public good. The sources of the human rights to water, as I have stated before, the 2 covenants and local law and the UNDHR. The content of human rights to water outlines the obligation of each state. How soon must these rights be implemented? Water for domestic and personal use? How is that distinguishable? Water to produce food, should government allow for tax exemption if the company can produce SDG footprints? Transboundary implications for the non-extraterritorial of human rights law. When there are disputes, we look for dispute settlement procedures and methods that can allow in international law access to justice should anything wrong be or suddenly occurred whilst underlying contractual obligations. As seen here, next slide please. Next slide, please. In the case of bulk transfer of fresh water, private contractual remedies negotiated between parties or remedies available in public international law rather than remedies provided for in trade agreements dispute, for example, GATS and NAFTA, in remedies in the public international law. So should you have an international contract, usually there is an article in that contractual obligation that outlines should there be any dispute, a place or forum where that country's law would be utilized to settle any disagreements. The examples here for export bulk of water is seen in cases like dams, of which usually, for example, in Malaysia, in constructing the dam, the indigenous people are usually displaced. Without proper environmental impact assessment and openness to solicit suggestion before the project even started must be adhered to strictly. Next is bulk water transfer arrangements. For example, in the case of transfer of water between neighboring states, for example, between Malaysia and Singapore, as seen with a local entity there, which is the state of Johor. Johor is a state that supplies water to Singapore. And it has been one of the thorns that has always been in the way of Malaysia creating peaceful negotiations of future projects in Singapore. Next is national and local efforts to limit exports of water. For example, should private entities be given leeways of taxation if they manage a clean bill of health with regards to SDG footprint? This is something to consider, and I invite all the researchers out there to put our heads together and come up with a solution. Okay. Next is the SDG compliance as seen in the next slide. Those are all the 17 goals of the SDG. Just now in the colorful format, that's the 17 goals of the SDG. So the Sustainable Development Goals, also recognized as the global goals, were adopted by all United Nations members, including Malaysia and Indonesia, in 2015 as a new universal call to action to end poverty, safeguard the planet, and guarantee that all people enjoy peace and prosperity by 2030. So the SDG that I'm specifically looking into for my research is clean water and sanitation with regards to human rights. How does human rights help to realize clean water and sanitation under Goal 6? So among the implementation that Malaysia did was to give tax exemption. in my full paper, there is a listing of actually some of the measures. Since time is of the essence, if you contact me via my email as seen here in the PowerPoint, I can send you my full paper and you can see the outline of the commitment and what Malaysia did in order to satisfy all criteria for a valid SDG achievement. As a conclusion, no one disputes that every human being should have a right to sufficient, safe, acceptable, physically accessible and affordable water. In line with SDG, the action of the ESC committee in adopting the general comment on the rights to water is therefore an important step in the right direction. Human rights and SDG are mutually reinforcing. Human rights provide a normative framework for the SDGs, ensuring that development efforts respect the dignity and well-being of all individuals, while the SDGs provide a practical roadmap for realizing human rights by addressing the root causes of poverty, inequality, environment degradation. Together, they aim to create a more just, equitable, and sustainable world. Human rights and the SDG are interconnected. The realization of many SDG depends on respecting and protecting human rights. For example, achieving gender equality, SDG 5, is closely linked to upholding women's and girls' rights, their right for education, for safe well-being. This aligns with the human rights principle of non-discrimination, emphasizing that all individuals should benefit from development efforts regardless of their background or circumstances. Human rights and SDG, I leave you that thought. Together, we aim to create a more just, equitable, and sustainable world. Thank you. And before that, I share with you some pictures that we took yesterday. If you see, there is a, before that, there is a cat photo. That is what was seen on Asia flight. If you browse in the duty-free magazine, 30% will be given to animal shelter. If, for me personally, I'm a lover of pets. I have a cat myself. When I see a product like this, which gives back to cat shelters and ensure their safety, I would rather buy, me personally, this product rather than a competing product. But that is just me. I was wondering if the researchers could see whether or not if a company puts SDG to ensure that we are doing green economy and saving paper and publicize that, would that make a difference? Would the public buy more of their product or not? That's something to ponder. Assalamualaikum. Thank you very much.
Thank you very much, Professor Rosalie.
Should you have any questions, please do not hesitate to email me and during the Q&A session. Thank you. Thank you for your attention.
Thank you very much, Professor Rosalie. For our next speaker is Professor Dora Marinova. Please, Professor.
Hi, everybody. So nice to see you all. And obviously, I'm very grateful to director and the chair of the conference organizers, but also to my beautiful student tree who provided the connection with the university. Thank you so much also to the Dean of Law, and I also want to thank the people who have been looking after me so wonderfully. Handy is one of them, Uriel, who was the one who was in contact with me on email, through SMS, and also Aura has been absolutely fantastic looking after me. But most importantly, we are on the land of the traditional Indonesian people, and we often forget about the wisdom and the knowledge that traditional people have. And that is particularly true about Australia, because Australia is a country that has ignored traditional knowledge for many, many years. So we always pay respect these days and acknowledge the fact that there has been a lot of damage done to traditional knowledge. And I'm so pleased to see all the traditional patterns and foods and things that Indonesia keeps, and it's really inspiring to be here. So the speaker before me, Rosalinda, was very helpful in establishing the context for my presentation as well, because I also want to talk about the SDGs, the Sustainable Development Goals, and particularly about the newest human right, which is the right to a clean, healthy, and sustainable environment. Can we please have the presentation? Okay, and I want to start with this story. What you see there is called horizontal falls. It's like a waterfall, but it's not vertical, it's horizontal. And it's caused by the tide that changes. As you can see, these big rocks, it's in up north in Western Australia. I actually visited when we closed the state during COVID-19. So the picture is from 2020 when I visited. So if you are there on just looking on a boat, being on the first slide, you don't understand what exactly is happening unless you see the situation from above, and that's the slide that you can see now. And so you have these two narrow passages which delay the way the water goes from one end to the other. And there is only 1 hour of opportunity to get on a boat from one end to the other. And that's part of the Bacania archipelago, which has thousands of islands. Being in Indonesia, you know the beauty and the charm and the environment that islands provide. But for me, going there, I made this analogy with the time that we have to address climate change, because we have only 1 hour to be able to go by boat through this narrow passage. And we similarly have a very, very short opportunity to address climate change and keep our planet as beautiful as we've seen it from above, much higher than being on a boat. However, what has happened is that ever since industrialization, and Western countries are particularly responsible for that, we have caused a lot of environmental damage. If you can go to the next slide, please. And the person behind the Sustainable Development Goals has been Jeffrey Sachs, professor at Columbia University, and also the president of the Sustainable Development Solutions Network. And what Jeff has been talking about is that the pandemic has derailed the progress along the Sustainable Development Goals. And on top of that, we have the war conflict in Europe, which has further derailed the attention to climate change and to all the other sustainability priorities covered in the Sustainable Development Goals. So we need to act and concentrate efforts to achieve the SDGs. And as Rosalinda explained, they started in 2016, and we are now halfway through that period where we need to act on climate change. So next slide, please. And one of the issues that we have is that it's not only climate change, it's biodiversity loss, it's pollution, particularly plastics pollution everywhere, it's reduction in soil fertility. So the way we describe the current situation as we are in 2023 is a polycrisis. So it's not one crisis, it's many crises merged into one. And by the way, this word polycrisis was adopted by the Cambridge Dictionary a few days ago on the 20th of September. And people need to be protected not just in terms of their immediate health, they also need to be protected in terms of the natural environment where they exist. So in this time of great disagreement, of conflict, confusion and suffering, we actually need to do something along the Sustainable Development Goals. Next slide, please. And last year in July, we actually had a new human right added to the Universal Declaration of Human Rights. And that is the right to a clean, healthy and sustainable environment. It's interesting that Australia is one of the few countries that hasn't got a Human Rights Act or Human Rights Bill, but irrespective of the fact that it hasn't been invested in legislation, it is still something that guides behavior. And similarly, the SDGs are not legally binding, but they still guide behavior, not just globally, but also in each country. And it was very interesting that for the state that I come from, Western Australia, which is the nearest place to Indonesia, we had the state budget organized by the Sustainable Development Goals back 2 years ago. And now, if you can click please, now we are going almost like goal by goal. So the next year was climate change. At the moment, the focus is on energy. So if you can click the next one, yes. So that's the state budget of Western Australia. And next slide, please. So the new human right is a framework that encourages governments, businesses, civil society to accelerate progress. And it was around the basic human rights. There are 30 articles, maybe you know them better than I do because I don't have a legal background, but now by extension the natural environment protection of the natural environment forms part of the universal human rights. And what is covered in this new human right is the basics. Clean air. We don't have air for 3 minutes and we are gone. Safe climate, because the calamities of climate, when we have droughts and floods, it's something that we really need to be able to exist. Access to safe drinking water and sanitation, and this was something that the previous speaker spoke about. We need healthy biodiversity and ecosystem. We need toxic-free environments where we can exist, where we can live, we can work, we can play. And we need to have this healthy and sustainable production of food, because food is what sustains us. And everything else is subordinated. When we talk about energy, when we talk about industry, when we talk about transport, housing, everything else is subordinated to these 6 substantial elements of the new human right. And I should take this a step further. Is it just a human right, or is it a right to all species that inhabit this planet? If you talk to DNA analysts, they say that we are not that different to the animal world. We perceive ourselves different, but if you look at our DNA, we're actually quite related. And with one of my master students, we wrote some time ago several years ago, that they should be SDG 18, which actually talks about the rights and how we treat animals on this planet. So I see it personally as a right of all sentient beings that exist on this planet. And this is formulated as justice or planetary justice that should go across all species, not only us as being human. And what we have done as humans, we have caused a lot of deterioration of the environment that we share with the other species, to the extent that we have not witnessed biodiversity loss, particularly in Australia, as fast as it is happening now. It's about 200 species that we are losing per year in Australia. And part of that is because the way we have been producing food, and some of the statistics are absolutely mind-blowing. It's almost, it's so difficult to actually comprehend how we managed to get there. But at the moment, 96% of the mammalian mass on the planet is livestock. So the way we've organized our food, we have killed or caused native animals to disappear. So when I'm asking, is there a tiger? Well, it's very difficult to see tigers in their native habitats. It's very difficult to see some of the native animals in Australia as well, because we have expanded the way we produce food, and we have destroyed native habitats that support other species. But let's go back to SDGs. Each year, the United Nations produce an assessment, because the 17 goals come with 169 indicators and targets, and each year there is a report that shows how various countries are progressing towards achieving the Sustainable Development Goals. And I pulled, obviously, Australia and Indonesia. So this is a spidergram that shows you, so the blue color, if it goes towards the periphery, outside of the circle, that means that we are doing well. So the outside circle is 100%. So I don't know whether you can see the screens that well, but I normally have a question. In what SDG Indonesia is doing well than Australia? SDG 1, okay? Australia is almost at 100%. SDG 2, SDG 1 is, what is SDG 1, Rosalinda? No, poverty. SDG 2, what is SDG 2? No hunger. So, SDG 2, no hunger, Australia is actually doing worse than Indonesia. How could that be? You would say, Australia is such a wealthy country, we export a lot of food. Well, the reason why Australia is doing worse than Indonesia is because our diet is not healthy, because we are very much dependent on dietary choices that are not good not only for us as human species, they are also not good for the planet. And I won't test you on all the other SDGs, but I still want to stress that SDG 13, which is about climate action, Australia is doing worse, much worse than Indonesia. Going back to that SDG 2, the issues around hunger, this graph shows you what is particularly meat consumption per person in some countries per year. So the one to the left are the countries that have the highest meat consumption. And you can see that Australia is up there second, and Indonesia is much further right, where we have a much lower meat consumption per person. What Indonesia has is doing much better than Australia is the intake of fish. So this is that graph. So you can see Indonesians consume probably twice more than Australians in terms of fish. But still, if we see how per capita meat and fish supply has developed throughout the years from 1961 till 2020, where we have the latest data, we've seen increased supply of meat and fish, but meat in particular, which has a very, very big impact, negative impact on the natural environment. There is so much evidence, and I don't have enough time to go through that, but what I want to say is that a Western type of diet is causing a lot of non-communicable diseases, including obesity. Can we have the next slide, please? Including obesity, which has now become a world concern. Obesity amongst Australian adults is at 67%. Amongst Australian children is at 25%. 1 in 4 kids are now experiencing some of the symptoms of old age, which is diabetes, for example, diabetes 2 or high blood pressure. If you look at the statistics for Indonesia, they're much, much lower. You know, only 20% about adults and only 8% amongst children. So my message to you is to keep all the goodness that you have in your traditional diets and that mixture of nutrients that provide better nutrition but also are protective of the natural environment. Because why, next slide please, because why am I saying that going for livestock is a big problem is because livestock requires a lot of land, and we have a limited amount of land on this planet. This graph, I hope you can see it, but all settlements, all villages and towns and cities, infrastructure, roads, factories, you name it, they take only 1% of the land mass on this planet. We have 8 billion population, but we actually live on 1% of the land mass of the planet, while livestock globally takes 27% of the land mass. 27%. All tropical forests take 26%. The crops that we eat directly, the crops for human consumption, take only 7% of the land mass. And what is happening there is that we need to reconsider how we are producing food, and this is where we need to focus on countries such as the United States or Australia or the wealthy countries where the consumption of meat has gone way above what is healthy and what is possible on this planet. In fact, 80% of the planet's resources are being used to produce food only for 20% of the world population. Yesterday I was talking on Australian radio around the concept of introducing a new tax on meat, because you need to hold those who are having this high consumption responsible for the damage that they're doing. So if you can go, next slide, actually skip. Okay. Next slide is the message that we cannot look at the health of human population without looking at the health of the natural environment. And there are two concepts how we assess the health of the natural environment and the health of the people who live on this. One is planetary boundaries, and the other one is the donut economy or the donut economics. I don't like the term of the second one, but this is how it has come. So next slide, please. The planetary boundaries started back in 2009. It's an assessment that looks at particular measures that describe the health of our planet. One is climate change, the other one is biodiversity, you have nitrogen, phosphorus, you have acidification, you have land use change. And when this assessment was done first in 2009, they did like a traffic light presentation. If it's green, it's good. If it's yellow, warning signs. If it goes red, we have transgressed the boundaries of what the planet can sustain. So in 2009, we had 3 boundaries crossed. If you can go on the next slide, please. In 2023, the assessment was produced probably a few weeks ago. It was published in Science in September. We have now crossed 6 boundaries. And some of the new boundaries that have been crossed relate to plastics pollution, or novelties, the way they describe them, really, really significant, relate to phosphorus, which we need to improve soil fertility. And the situation with climate change has gone much, much worse. So if we can have the next slide, please. Yes, and agriculture has been by far responsible for crossing some of these planetary boundaries. So that's an assessment which was based on the 2015, and the little dots show you the responsibility of the way we grow food. And I should stress that it's the Western type of agriculture, Western type of producing food that is contributing vastly to this environmental deterioration. If I can go to the next slide, please, which is the donut economy. And the donut economy is saying, okay, we can't just look at the way, the health of the environment. We also need to live comfortable life as a society. We need to provide education. We need to provide healthcare. We need to provide energy. Our political systems have to be working for the vast population. So that what this concept brought together, essentially as saying that we should try to stay within the green area, so live in a healthy environment and provide good quality of life for everybody. And this concept of the donut economy combined with the planetary boundaries is actually at the core of the Sustainable Development Goals, and this is why we ended up with 17 development goals. Okay, if we can skip a couple, actually 3 slides, one more, and one more. Thank you. By training, I'm an economist. And in economics, we talk about goods and services. We talk about them being private or public. What has happened is that everything that I've spoken so far, climate change and biodiversity and pollution, all these are public goods that are not just under control of one particular country. They're global public goods. And unless we have mechanisms to provide for these global public goods and don't allow them to turn into global public bads, we won't have a good quality of life. And next slide, please. Yes, the emissions report, the latest emissions report shows us that the polycrisis that I spoke about is only deteriorating. Emissions are going up, and we are not acting fast enough on climate change. Next slide, please. To the extent that now Antonio Guterres, the current Secretary General of the United Nations, is describing the current situation, not climate change, not global warming, he used global boiling, and his latest description was, we have opened the gates to hell. So we need to act. And next slide, please. And this is particularly important for our children, because our children are the ones that are going to inherit the planet from us, and they're already showing anxiety, particularly children in Australia, have been very proactive because they don't want to deal with the problems that previous generations, including baby boomers like me, have created for them. Next slide, please. So the children are on the streets protesting. They are also starting to file legal cases against ministers and governments in Australia, saying to the government in the courts, you are not protecting our rights, you are not protecting us, you are not protecting our future. So this was the warning part of my presentation. Next slide, please, is we need to act. And the way we need to act is through being innovative. We are a very clever species, and we have been very creative and very innovative. But our innovation now has to be transforming innovation. So next slide, please, where the focus of that innovation is how we achieve the SDGs, how we live in a sustainable way. This conference, if you can skip a couple of slides, this conference is extremely timely because the right, next one, the right to a clean environment is something that has been recognized by the United Nations, and we are talking here about how we can live, how we can look after social justice. But the next slide, please. The pathway to a human right, to a clean environment, the most important goal for that from the SDGs is SDG 16, which is global peace. Unless we have an environment where we're no longer fighting and we realize that we are all sharing the global public good of living on this planet, we won't be able to achieve any of the SDGs. And global peace will allow us to ignite creativity and come up with solutions that will allow us to deal with energy, have better food production systems, and essentially forget about all the tensions, but being able to share the same planet and keep it as beautiful as we can see it from above. Thank you.
Thank you, Professor Dora Marinova. We're moving to our next speaker, Professor Hipnu Nugroho. Time is yours. Waktunya, Profesor, silakan.
Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Topik yang saya sampaikan ini suatu yang baru, yang saya kira nyambung dengan apa yang disampaikan Pak CA, khususnya para penegak hukum, terkait dengan asas Suprema Lex Exto Principle. Ladies and gentlemen, Suprema Lex Exto Principle and this implementation in Indonesia. Background, and the Suprema Lex Exto Principle was first coined by the ancient Roman philosopher Marcus Tullius in book titled De Legibus. De Legibus ini yang kalau kita lihat situasi COVID sekarang, kemarin, ini yang menjadikan senjata bagi Pak Presiden bahwa keselamatan rakyat adalah hukum yang tertinggi. This adagium sickness, the safety of well-being of the people is the Hague's law. During the COVID-19 pandemic, the government advocate for this principle and carrying out rescue action for the severely affected population due to COVID. The Suprema Lex Exto Principle was adopted as part of preventive measures to mitigasi the impact of COVID-19, leading as government, agency, and state institution to regulation of employee work and serve the public and specific and limited manner. Slowly but surely, of approximately the 2 years, the government exercised caution to safeguard the population, and 2023 the restrictions have been and life has returned to normal. Ini yang menjadi masalah, makanya kemarin banyak kasus Bapak Ibu terkait Departemen Perdagangan yang import tinggi, Departemen Sosial, gula, beras, APD, Departemen Kesehatan, luar biasa terjadi tanda petik kerugian-kerugian yang dimungkinkan menjadikan suatu perjalanan. Jadi pas seperti sampaikan oleh Pak Jaksa Agung, transparansi dan asas kepatutan dalam pengadaan menjadikan suatu yang penting. Bukan berlindung pada asas suprema lex exto. The problem, how did the suprema lex exto principle implement during COVID-19 in Indonesia? In the Social Handling Network Program, jadi ada program jaring pengaman sosial. Ya. Jaring pengaman sosial, kalau Bapak Ibu lihat kemarin terkait dengan bansos bermasalah, e-marketing bermasalah, beras bermasalah, e-market bermasalah, jam bermasalah sosial. Ya. The government issue, government regulation in the of-life Perpu, nah, number 1 of 2020. Jadi Perpu ini merupakan senjata tampaknya oleh pihak-pihak tertentu. Nah, ya. Jadi Perpu ini PHP artinya. Ya. And financial system stability of handling of COVID-19 pandemic. The government actuality include more provision of financial policy between the central and regional government, financial system stability, tax policy, national economic recovery, and so on. Nah, ini yang problem sekarang. Jadi tampaknya dalam keuangan itu betul ketika itu, belum betul ketika besok. Ini pengelolaan teman-teman yang di bidang keuangan, hari ini betul, belum tentu besok betul. Apalagi kalau hari ini salah, jangan harap besok tidak ketemu. Itu Pak Jaksa-Jaksa ya. Ini mumpung dari Pak Kajati WA semua. Ini bagian penting bagi penegakan hukum terkait dengan kasus-kasus yang sekarang berimbas dari COVID-19. However, despite this provision, this clause in Article 27 of Perpu numbers 1 of 2012, the have raised deep question among the public. Jadi walaupun dalam Perpu itu mengucapkan adalah semua penegak hukum, penyelenggara negara tidak dapat dituntut pidana atau perdata. Kecuali, nah, kecuali ini yang menjadikan perhatian. Nah, the application of supreme lex exto principle underlying of government handling of COVID-19 Indonesia in concern improvement. The principle socially popular supreme lex exto of the safety of the people shall be in the supreme law can only be applied when the government declares a state emergency. However, at present the government is not implying such of emergency status in this pandemic management. Artinya kadang berlindung bahwa itu kan perintah undang-undang. itu kan perintah presiden. Nah, sekarang kalau Bapak Ibu lihat kasus Pertamina, itu perintah presiden. Nah, itu perintah menteri, itu perintah semua berlindung. Apalagi kalau terkait dengan pasal 50 Bapak-bapak penegak hukum. Seseorang yang menjalankan penegak hukum tidak dapat dipidana. Nah, ini yang sering dijadikan acuan. Perintah yang mana dulu? Ini yang jadikan perdebatan di antara saya kira mahasiswa hukum yang era sekarang tampaknya perintah mengungkap kasus-kasus COVID yang terjadi kerugian kemarin itu. Conclusion, ya, the implementation of supreme legislative principle dari COVID-19 ya, Indonesia is a principle not been fully implemented as expected by the government. Ini rupanya menyajikan pacuan dulu, tata kelola, SOP. Nah, jadi ketika tidak ada suatu SOP dilanggar, berpotensi. Ya. Walaupun SOP itu kalau terkait dengan BUMN kadang-kadang cepat-cepatan untuk mencari keuntungan. The next hope of the government ensure at the interest of the COVID effect. Public are not compressed and directly eliminated concern about of integrity of policymakers. Ini yang kita lihat dari data-data yang ada luar biasa antara perencanaan dan pelaksanaan. Sehingga potensi sifat melawan hukumnya tinggi sekali. Potensi bahwa dia sadar bahwa itu keadaan yang tidak darurat tinggi sekali. Nah, is that suspect the anti-corruption behavior. Sehingga kalau memang terjadi salah, jangan dulu. Tapi semua berlindung. We should be the main base of carrying of the task handling COVID-19 and still not effective execution. Artinya, kalau kita mengedepankan asas the supreme ini, memang idealnya pemerintah presiden ketika itu meletakkan sebagai situasi darurat seperti dalam Undang-Undang 45. Tapi ternyata Indonesia tidak dalam keadaan darurat, karena kalau darurat itu bagian dari semua bisa dilaksanakan tanpa ada suatu kontrol. Inilah permasalahan pertentangan normatif yang terkait dengan Perpu 1 2002 yang merupakan kebijakan yang tidak dapat tuntut, tapi juga pemerintah presiden belum menentukan sebagai keadaan darurat seperti Undang 45. Sehingga menurut kami dari kasus-kasus yang ini tidak dapat bisa dipertanggungjawabkan karena pemerintah bukan dalam keadaan darurat, dalam keadaan normal. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Hibnu Nugroho. All right. To summarize from all the three speakers, from Professor Roslina, water as a basic need to human rights, and government in every country must provide protective from water deprivation. This is a basic of human rights to establish sustainable development goals. Both human rights and SDG are mutually reinforcing each other. And human rights provide normative framework, and SDG provide practical roadmap to establish this human right. By comparison, in Indonesia also happens the same things, like the big company usually fighting about the concession to collecting the natural water spring, to capitalize from it and to gain from it. And it's become today's issue also in Indonesia, about water in Indonesia. For Professor Dora Marinova, the climate action is part of the UN SDG. Protecting people right is the first health is the first priority. Polycrisis is emerged and needs mitigation. Clean air, soft climate, access to clean water, healthy ecosystem, toxic-free environment, healthy and sustainably produced food, clean energy is need to be organized. And some say that the carbon-based life form like us is the main pollutant of this world. Some say it like that. Okay, and for Professor Hibnu Nugroho, our last speaker, like S2 principle signifies the safety of well-being of the people at its highest law. Like Exto was implemented during COVID-19 in Indonesia through jejaring pengaman sosial, was apparently this principle has not been fully implemented as expected by the government, but the government ensures the interests of COVID case are not compromised. Although it is suspected that anti-corruption behavior, which should be the main basis for carrying out the task, still handling COVID-19 is not effectively executed. I think this is the summary from the all three speakers for today, and now we are opening the Q&A session. For the first session, I will giving the chance for 3 questions, and I need to remind anyone who joining this international conference via Zoom, they could using the raise hand feature to giving question for the all three speaker. For the first session here, there's 1 and there's 2. Any online question? And all right, over there, there's online question. So I will open to these 3 questions first. And the gentleman with the white shirt, please state your name and who's you addressing the question to.
I have question for Prof. Dora Marinova. That's the question. What is the important role of the United Nations Sustainable Development Goals is resolving issue related to climate change? Thank you.
The answer will be last when we are already collecting all the questions. For the second question, over there. Over there. Your name and state your question addresses to.
Okay, thank you very much for the time. My name is Amelia Safaatorik and I'm from IPDN, Institut Pemerintahan Dalam Negeri. I have a question to Professor Dora Marinova. And what do you think Australia's government need to do for fulfilling the second goals SDG, which is the zero hunger that you have explained before, that Indonesia is 2 times better than Australia. Also considering on the climate change that happened this time, which is those that associate with El Nino conditions. Thank you very much.
All right, and the online question, over there, the gentleman with batik, the blue batik, yes?
Hello, my name is Junaidi, me from Jakarta, and I would like to ask for Prof. Dora in relation with the foreign direct investment, because it's really interesting that your interest is about the sustainability, research, sustainability investment. And nowadays in Indonesia, we have problems with the FDI in related with the sustainability environments. So what the strategy should be taken by the government in related with the FDI to relate with the sustainability science and the sustainability research, because sometimes they don't, they just receive the FDI without thinking about the sustainability. And now we have a problem with the CPO in Indonesia because of the European Union have blockade the CPO to be entering the EU because of the transfer from the plantation from the forestry. And then now the European Union giving this something like the regulation about the CPO from the country, that the transfer from the plantation is transferred from the forestry. And it could be the problem from the Indonesia and also maybe Malaysia could be a problem with the CPO from the country, from Indonesia and from the Malaysia. And I have one question for Prof. Hivnu, in related with the speech from the Attorney Generals. The Attorney General mentioned about how important about the undang-undang administrasi pemerintahan in related with the governance. And some others of the criminal law also we have to look after about the implementation about the governance in related with the undang-undang administrasi pemerintahan. And some of the criminal cases also related with the governance matters. So what should first to be set out in related with the undang-undang administrasi pemerintahan, or we have to follow with the criminal law, because of some of the criminal law also related with the PTUN, because of we have to act with the how the PTUN is related. And we're talking about the regime administrasi pemerintahan now after the undang-undang administrasi pemerintahan, karena kita juga perlu periksa tentang PMH penguasa itu bagaimana nanti relasinya berkaitan dengan hukum pidana. Mana yang harus diperiksa terlebih dahulu. Karena kita sedang mengalami beberapa macam yang tadi disruption related with the governance in one side, and the other side is about the criminal cases. And the other side about the development. What we should be thinking, and tadi juga Pak Jaksa Agung juga itu kasih pesan buat jaksa bagaimana jaksa harus bersikap seharusnya dalam menyikapi masalah yang berkaitan dengan ekonomi pada satu sisi, hukum pidana di sisi yang lain gitu, dan kita punya rezim administrasi pemerintahan pasca Undang-Undang 2014 itu tadi pesan yang saya tangkap dari Pak Jaksa Agung. Terima kasih.
Okay, I think that's the end of the first session. The Q&A session. We'll go to first Professor Dora to answer the question first.
So thank you all for listening and for asking questions. They're really tough questions to answer. And I'll try my best, but we are living in a polycrisis where the answers have to come from every single one of us. It's not just the government. There is role for civil society, there is role for business. So the first question was about SDGs and climate change. One of the SDGs, SDG 13, has goals that relate to climate action. So the SDGs accept that we need to do something about it. The fact that the Australian government, for example, needs to report on the SDGs. They're voluntary reports, but Australia does it. The fact that you need to report makes you think about your performance, makes you think about your emissions, makes you think about the changes that need to go all across your economy. So that's the power of civil society, I would say. We had elections, we had federal elections, was it 2 years ago? When a lot of politicians lost their jobs because they did not act on climate change. And Australia has two main parties. You know, you have liberals that are right-wing, and you have you have Labour, which is left-wing. And we saw a lot of independent candidates that were successful entirely based on a climate change agenda, because it's not just the government, there is civil society that can push a lot government policies. And the SDGs, I was absolutely amazed that my state endorsed them as a way to distribute money in the state budget. So these kind of things, you cannot rely entirely on government. You need to work in collaboration. You need to work in partnerships. And SDGs have been a very, very powerful platform, including in the developing world. I've been doing work in Bangladesh. In Bangladesh, every single servant, their performance is assessed based on the country's achievement of the SDGs. Just imagine your performance being assessed on emissions or being assessed on energy. So they're very, very powerful too. The next question was how is the Australian government acting on SDG 2, on hunger? Some of the statistics from Australia are absolutely worrying because we see life expectancies drop for the first time. So for the first time since we had statistics on population, we see people's life expectancy diminish because we have diets that are not healthy. Australia has dietary guidelines. The dietary guidelines are really, really good, and they prescribe no more than 65 grams of red meat per day per person. But people don't follow that, and there is this perception that eating more meat is a level, is manifestation of your well-being. And particularly people who come as migrants from poorer countries to Australia, all of a sudden their meat consumption goes up because this is what they thought a good life is, without realizing the damage that they're doing to their own bodies as well as to the planet. What is the role of the government? The role of the government is limited in the sense it can send the right messages, but at the same time it should also stop the wrong messages. There is many advertisements that are everywhere in Australia from the Meat and Livestock Association that pushes people to eat more meat. The only age group that consumes healthy levels, but they're not like every age group in Australia eats much more than what the dietary guidelines prescribe. The only group that is just on the cusp are young girls. And at the same time, the government is allowing the private sector to push and to essentially market products that are not healthy. In a similar way as the Australian government has acted in relation to tobacco or drinking, they should have a more proactive stance, given all the evidence. I can talk about this forever. Handy is going to stop me. Okay, the foreign direct investment. That's again a very tough question. Thank you for asking it. Australia is in the same group as Indonesia. Our products are also going to be taxed additionally by the European Union, even rejected, because we don't act on climate change. So unless you show that you are doing something in that area, you have to pay the price, and the price is economic price. In a globalized economy, you know, there will be problems. Having said that, Europe was doing amazingly well in sustainability before we saw the war conflict in Ukraine. So now the world has become even more complex, and a lot of the decisions are not just economic, a lot of the decisions have become geopolitical. And for me, it's very important to build relationships and build, how can I say, trust and act in collaboration, in partnerships, rather than just using economic or political sanctions. So thank you.
Professor Dora has already answered the question. Is there any feedbacks from anyone? Ada feedback dari Bapak Ende? Okay, please. Okay. There's feedback. Professor Dora. Yeah. Mic untuk Bapak berbaju putih. Saya mohon bantuannya.
I hope I understood the questions correctly.
Okay, thank you, Prof. Dora Marianova. I have one question again. That's a question. Sustainable Development Goals consist of 17 goals with various targets and indicators aimed at overcoming various global change and covering sustainable development, one is which is a climate action. What about which one for 17 goals with a various target? Thank you.
Is it reading about the 17 schools that you made in the presentation?
Yes. Sorry, I'm not sure I understand the question. Are you asking which is the most important or?
Jadi salah satu dari 17 target dari SDGs ini, salah satunya kan ada climate action, dan maksud dari climate action itu sendiri itu apa? Seperti itu.
The question around the implementation climate action.
Yes, thank you.
Well, each country has to address it depending on what are the characteristics of its economy. I can talk from the perspective of the Australian government. There are big debates in Australia at the moment whether there should be any new projects based on fossil fuel. The Australian government is no longer approving new coal-based projects, but we have gas and we are moving towards hydrogen economy. So it depends on the characteristics of your economy. You need to commit to reduction of greenhouse gas emissions or carbon dioxide or carbon neutrality or net zero. And each country has put a target. In Australia, it's 45% reduction by 2030. And where these reductions are going to come, it depends on the structure of your economy. So that covers new projects that are being approved, that covers shift to better energy sources, better transport solutions. So it's a very, very complex but very important agenda. So
Okay, thank you. I understand for this question. Thank you.
Okay, thank you very much. The question for Professor Hipnu Nugroho.
Relating the three questions. For the first one, I think very strict enforcement measures should be given to polluters who pollute our world. And number two, must create, publish or perish, as you say. You must publicize the SDG so that the public can be aware of what it entails. And you must educate our public from an early age relating to this matter. And lastly, as for sustainability, I would think that for example, you create measurement tools, for example, impact assessment on the environment should a project arise, and collect data from neighborhood, desa, or the peoples of lingkungan, locality, whether or not they agree to such a development. This must all be incorporated into discussion with the general public before such a development is undertaken. Thank you very much.
Yeah. terima kasih. Jadi ada benturan undang-undang administrasi, undang-undang pidana, apalagi korupsi. Ya. Memang kalau kita lihat dari perkembangan kasus supremasi Esto yang muncul di berbagai wilayah, potensi administrasi mungkin, ya mungkin. Tapi kalau kita lihat kasus-kasus yang besar, gula, beras, minyak, itu muncul dari pengadaan. Jadi kalau kita melihat pengadaan yang lost kontak, ya, loss, betul-betul loss. Ya. Jadi ada ketidaksinkronan antara perencanaan dan eksekusi. Nah, disinilah muncul penegak hukum yang sekarang menjadikan itu masalah hukum. Masalah hukum. Oleh karena itu betul. Jadi kalau saudara mendekatkan pada itu kepentingan administrasi bisa. Pertanyaannya, coba itu dilakukan. Yang selama ini tidak pernah dilakukan. Ya, hanya terkait dengan kasus-kasus kecil tingkat pemerintahan kabupaten, provinsi yang terkait dengan sirkulasi administrasi muncul. Tapi terkait COVID, bansos, APD, itu pengadaan yang menjadikan situasi tidak normal. Oleh karena itu dalam hal berbagai kasus ini kita melihat aspek mens rea, sifat plan hukumnya, asas kepatutan, asas transparansi. Ketika situasi dibutuhkan, bagaimana pada suatu pembelian. Itulah yang menjadikan permasalahan-permasalahan itu muncul yang sekarang di berbagai daerah. Oleh karena itu penegak hukum agak gampang juga, khususnya jaksa, khususnya polisi. Dikait pemerintahan bisa juga berpikir, oh ini salah administrasi. Nah, inilah saya kira yang menjadikan pertentangan kita, bagaimana memberikan jalan tengah. Kalau itu memang administrasi, betul kita selesaikan administrasi. Toh di permasalahan hukum itu banyak alternatif penyelesaian, alternatif. Sehingga yang terjadi penyelesaian hukum ya, penyelesaian betul-betul penyelesaian terakhir, asas terakhir. Jadi tidak semua dibawa ke ranah pidana. Permasalahannya, kerugiannya triliunan, miliaran. Pertanyaan yang kedua, mampukah pemerintahan baru mengembalikan kerugian yang terjadi? Ini problem terhadap pengadaan ketika situasi penanggulangan COVID-19. Terima kasih.
Okay, terima kasih Profesor Ibnu Nugroho. Because the time has almost over for this session, I think that is the end of the Q&A session, and I will asking a closing statement from each one of you. Is there any closing statement from Professor Dora? Any closing statement?
What I want to say to you is the issues that we covered are quite complex, but I have a lot of hope if we want to achieve something, we'll find ways of resolving issues. And it's not just creativity, it's also thinking about it. It's also realizing that the issue is there and trying to find ways to work collaboratively. And being, Australia being so close to Indonesia, in many ways I keep saying Australia is so lucky to have Indonesia as a neighbor, because we have so much in common, and there is a lot of good things that we can learn both ways. So I'm very hopeful for the future.
Thank you. Professor Rosalinda, is there any closing statement?
there is a hope for our children that us as adults instill in them good upbringing and education so that they will maintain this earth for their children. As stated in various United Nations meetings, we mustn't leave anyone behind, inshallah. Thank you very much.
Ya, terhadap saya bahwa asas suprema lex exto itu adalah politik hukum, politik pengendalian COVID, yang mana pemerintah mempunyai kewajiban menyelamatkan rakyat. Oleh karena itu, kalau penyelesaian politik yang kemudian ada perpu politik diselesaikan hukum, kayaknya tidak ada suatu hubungan koordinasi yang baik. Sehingga kalau memang politik harusnya diselesaikan dengan politik hukum. Bagaimana secara normatifnya? Pemerintah mengadakan dalam keadaan darurat sesuai dengan Undang-Undang 45. Ini yang tidak dilakukan. Oleh karena itu ada suatu kegambangan nanti dalam penyelesaian antara para penegak hukum dan bagaimana pengelola dana COVID yang ada. Ya kita tunggu, mudah-mudahan ada suatu penyelesaian lain di dalam penyelesaian suatu COVID yang sekarang sudah selesai. Terima kasih.
Thank you very much. I think at this end of this discussion from the plenary session 1, I would like to thank you, every one of you. Thank you for all the speakers for these insightful and intriguing topics. Thank you for indulging all this experience with us, and thank you. Me from myself, I would like to say thank you very much. It's been a privilege, and this has been one of the greatest moments in my life. I bid you good day and goodbye.
Thank you, Pak Handito Baswara, for to moderate this plenary session 1. But please, to all ladies and gentlemen, please stay on stage because we're going to have a handover of certificate and also the trophy. And the certificate and also the trophy will be given by the chairman of the 3rd ICOLGAS, Dr. Teddy Sudrajat, SIMH. Please come to the stage. I'm sorry, it will be given by the Dean of the Faculty of Law, Professor Dr. Muhammad Fauzan. To all ladies and gentlemen, please do stand up.
Why do you want us? Beautiful. Thank you. Thank you. Thanks so much. Okay. Okay. Take a photo. Okay. Thank you. Thanks a lot.
Oh, certificate. Sorry.
Oh, there's a certificate as well.
No.
Wrong one. Thank you. Oh no. What's that? Wow, that's very big. Thank you. Thank you.
Thank you so much, Dean of the Faculty of Law, and to all ladies and gentlemen, all the speakers, you can go back to your seat. And finally, to all participants, you can have a break. While you take a break, you also can have a lunch to all participants at the corner of this ballroom. And to all invited guests, you can also have a lunch at the 5th floor of this hotel. Once again, to all participants, while you take a break, you also can have a lunch that you can take at the corner of this hall room. And to all, especially to all invited speakers, you can have lunch at the 5th floor of this hotel. Once again, at the 5th floor of this hotel.
Baik, terima kasih Bapak Ibu. Akan kami beritahukan untuk seluruh peserta dapat menikmati hidangan makan siang yang berada di depan ballroom. Dan untuk para tamu undangan telah kami sediakan makan siang di lantai 5. Terima kasih. Baik Bapak Ibu, silahkan menikmati hidangan makan siang yang sudah kami sediakan di belakang atau di dekat pintu ballroom. Dan bagi seluruh tamu undangan, telah kami sediakan makan siang di lantai 5. Terima kasih. Dan perlu kami informasikan kembali Bapak Ibu bahwa kita akan kembali di sini pada pukul 1 untuk melanjutkan acara dengan agenda plenary session 2.
To all participants, ladies and gentlemen, the plenary session 2 will be held at 1 p.m. in this ballroom. Once again, to all participants, after you take a break, there will be the second plenary session that will be held at 1 p.m. in this ballroom. Thank you.
Mas Banyumas TV. Pemirsa, pada acara The Third ICOLGAS International Conference on Law, Governance and Social Justice Fakultas Hukum Universitas Jenderal Sudirman, saat ini sudah masuki segmen 1 dan tentu saja ini kita masuki segmen break atau istirahat. Nah, kita akan kembali lagi pada saat jam 1 siang dan tentu saja kita akan memulai pada segmen 2 dengan speaker atau pembicara yang luar biasa lainnya.
pacar sing tak tresnani ninggalapi kowe liyane tekamu dadi tombol ngobati ati sing lara muga ikhlas mantun tekan besok
Tes. Mohon perhatian, Bapak Ibu, mengingat waktu kita juga nanti ada paralel, kita coba untuk menepati waktu. Tolong untuk tim teknisi untuk bisa menyiapkan rekening Zoom-nya, karena kita sudah hampir jam 1 ya? Jam 1? Iya, udah jam 1. Untuk moderator, Bu Ayu, belum ada di tempat? Ya, yang belum makan siang, segera makan siang, masih disediakan. Kemudian untuk yang lain yang mungkin sudah istirahat sholat dan sebagainya, kami mohon untuk bisa menempatkan diri kembali di tempat duduk, dan kita akan memulai sesi plenary session yang kedua. Terima kasih.
Cek. Cek.
To all participants, the next plenary session 2 will soon be started. So please come back to the hall room. To those of you who are still outside of the ballroom, so once again to all participants, the next plenary session 2 will be soon held and will be started anytime soon. So for those of you who are still outside of the ballroom, please do sit in the ballroom, and also please also be ready for the next plenary session 2, because we are going to be started anytime soon. So, ladies and gentlemen, we are going to start the second plenary session. So, once again, to those of you who are still outside of the ballroom, to please enter the ballroom because we are going to start the second plenary session.
Ya, Bapak Ibu yang masih berada di luar, kami persilakan untuk masuk ke dalam ballroom karena acara akan dilanjutkan dengan plenary session 2. Ladies and gentlemen, thank you for coming back to the ballroom. The next agenda is plenary session 2, which Mrs. Dr. Sri Wahyu Handayani SHMH will moderate.
But before that, we'd like to read the curriculum vitae of Mrs. Dr. Sri Wahyu Handayani SHMH. Mrs. Dr. Sri Wahyu is currently in charge as the Secretary of Institute of Research and Community Service of Jenderal Sudirman University. She did her bachelor and also her master degree at the Faculty of Law of Jenderal Sudirman University and doctoral program from the University of Indonesia. And her field of expertise are in agrarian law and also administrative law.
To Mrs. Dr. Sri Wahyu Handayani, the floor is yours.
Okay, thank you Ms. Eni Andreas. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Okay, good afternoon ladies and gentlemen, good afternoon distinguished speakers and also the participants. Welcome back to this conference room and thank you for staying with us and I hope you had a wonderful lunch and also a short break after the first session in this morning. Okay, and I will greet the participants who are online to the Zoom meeting. Hello, the participants in the Zoom meeting, are you still with us? Okay, thank you. I see there are some participants over there. Ladies and gentlemen, at the moment, I'm honorable to be moderator in this session. And in this session, we have 3 speakers and they will share their knowledge to us. And after that, I will welcome all of you to ask some questions to the speaker and also give comments to their presentation. And I will give chance to the participant in this room and also the participant in Zoom meeting. And the session will last for 2 hours, 60 minutes for presentation and 60 minutes for panel discussion. So I hope we can wrap up in 3 p.m. And ladies and gentlemen, now let me to address our first speaker, Profesor Dr. I Gusti Ayu Ketut Rahmi Handayani SHMH, the Dean of Faculty of Law Universitas 11 Maret. Prof. Ayu will join us through online via Zoom meeting. I will greet Prof. Ayu. Hello, Prof. Ayu. Good afternoon.
Afternoon.
Okay, how are you today?
I'm fine.
Okay, thank you very much for staying with us. And the second speaker is Professor Nurul Barizah, SILM, PhD, the head of Quality and Assurance Board, Universitas Airlangga. Prof. Nurul joined us through Zoom platform. I will greet Prof. Nurul. Hello, Prof. Nurul. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh.
Okay, thank you very much. How are you today?
Ibu Dr. Sri Wahyuni.
Okay, nice to see you. Nice to meet you via Zoom online. Okay, thank you for staying with us in this room. Okay, and now, the last but not least, the third speaker, Associate Professor Christopher M. Kaysen, GDLM from University of Washington. Mr. Kaysen, please kindly join me on the stage. Applause to Mr. Kaysen. Because he is the only one, the speaker, who stay in this room. Please. Okay, ladies and gentlemen, we cannot wait to learn more from the speaker. And without further ado, we will start our session today with Prof. Ayu as first speaker. Prof. Ayu, hello Prof. Ayu. Are you ready to become the first speaker? Hello, Prof. Ayu. Could you hear me clearly?
Hello.
Yeah, hello, Prof. Ayu. You will be the first speaker in the session. Are you ready?
Yeah.
Okay. Okay. Before that, I would like to give brief introduction about Prof. Ayu. Prof. Ayu was born in Jakarta on October 8, 1972, has been Professor of State Administrative Law since 2016, and has served as Dean of the Faculty of Law from 2019 until now. And she has 2 children, a son and a daughter. Prof. Ayu has bachelor degrees from Universitas 11 Maret Surakarta, master's degree and doctoral program from Gajah Mada University, Yogyakarta. She's also joined sandwich program at National University of Singapore. Prof. Ayu also gained intellectual property rights in 2022, including digital water quality measurements, water quality monitoring and distribution method based on EOT, digital water measurements. And Prof. Ayu will deliver her presentation entitled Reconstruction Model for Geothermal Utilization Regulation in Conservation Forest Areas, Emphasis on Meaningful Participation to Realize Community Independence in the Energy I am processed in East Nusa Tenggara and South Sumatra Province. Okay, let's give our warm welcome to Prof. Ayu. Prof. Ayu, the time is yours for 20 minutes.
Okay, thank you. Can you hear me?
Yes.
Hello, Ibu. Good evening.
Yes, good evening. Good afternoon, Prof. Ayu. Yes, we can hear you clearly.
Yeah. Did you see my presentation? I already.
Yes, we are ready. Okay, PPT, please. A technician help us to show her presentation.
Maybe could you help me share the presentation? I already started.
Technician, what's the problem? Oh, signal. Hello, Prof. Ayu.
Yeah.
Yeah.
Share point.
Yes, technician, please help to share the presentation.
Mungkin bisa dibantu sana.
Mas Ali, bisa share? Oke. Sudah share? Okay, Prof. Ayu, PPT is ready. You can start it. Prof. Ayu? Yes, Prof. Ayu, can you hear me?
Yeah.
Okay.
Yeah. Could I start?
Yes.
Thank you very much. Assalamualaikum. Good afternoon, ladies and honorable of law, Universitas Jenderal colleague Dr. Fauzan, the honorable doctor, my colleague Professor from Universitas Erlangga Surabaya, and occasion, see you again. I hope you remember UNS. And the honorable all participants, the third ICOLGAS, and ladies and gentlemen, good afternoon. Please let me share my station research about our research funding Ministry of the Republic. Please, can you hear me? Maybe jaringan. Yeah, you can hear me? Yeah, my topic is reconstruction model for geothermal utilization, regulation and conservation forest areas based on meaningful participation to realize community independence in energy transition process, especially East Nusa Tenggara and South Sumatra province. Ladies and gentlemen, we can see about our policy, our energy transition policy in Indonesia, which is we have the transition to carbon neutral until 2060. The first timeline for strategic achievements in achieving net zero emissions in the energy sector. We have 2025 reduced emissions of 196 and 98 million tons of CO2. And then 2035, we reduce emission of 275 million tons of CO2. And the last, our policy, we have 2050, in 2050, reduce emission of 956 million tons of CO2. So, this is the roadmap will be a form of joint commitment between the government stakeholders to reduce net zero emission in 2060. But we hope before 2060 we can net zero emission too. This data from Directorate General EBTKE, Ministry of Energy 2022. This is the map, the energy and many kind energy resource availability in Indonesia. We know we have many natural resources and mega biodiversity. And the energy resources available in Indonesia, there are biomass, marine water, coal, oil and natural gas, geothermal, etc. And we talk about geothermal energy, one of the clean energy. Many locations in Indonesia, we have potential geothermal energy. Ladies and gentlemen, we know that National General Energy have a plan target. In 2018, we have 8.35. You know, National Energy Plan target, and the 2025 we have increased target is 23%, and the last before 2060, especially 2050, we have 1%. The source data from National Energy Council and Pusat Data Informasi. And our legal basis, we talk about natural resources, and clean energy, especially geothermal energy, we have some basis. The first is 1945 Constitution of the Republic of Indonesia. The second is number 23 of 2014 concerning regional government. And the third, law number 21 of 2014 concerning geothermal energy. And law number 6 of 2023. The fourth is government regulation number 28 of 2016 concerning the amount and procedures for providing geothermal production bonus. And the fifth is government regulation number 7 of 2017 concerning geothermal energy, especially for indirect use. And the last is Ministry of Energy and Mineral Resources Regulation number 23 of 2017 concerning procedures for counseling, reporting, and reporting geothermal production bonuses. Ladies and gentlemen, this is a map of geothermal potential. We have the area in Indonesia, almost 13 areas. Many have potential geothermal energy. And today, our research group in Administrative Law and Energy Research Group in the Faculty of Law, Universitas Belajar, my institution, we have one research in geothermal, and we have some research in energy like water, geothermal, forestry, etc. But today we talk about geothermal potential energy. Especially in East Nusa Tenggara, we have 1,188.5 megawatt, in huge potential in the world. And we have some location to our research in Sumatra, especially South Sumatra in the second year. Our research is multi-year research, and this is the first, our group research years, the first years. And total resources in Indonesia, 23.76, 5.5 megawatt, and installed capacity still small, 2.130.7 megawatt. Ladies and gentlemen, this is one of location that our group research visit in geothermal development in NTT in the first year research. PLT Desa Wewo, Kabupaten Manggarai. This is the geothermal potential in East Nusa Tenggara. You know, there are 28 location of work area potential, and operating or existing geothermal potential in East Nusa Tenggara still small. You can see this data, the existing and operating still two locations, Ulumbu Manggarai and Korea, and we have some data, still initial preliminary survey, then detailed survey, and I think many and preliminary survey. And this is one map, Kementerian SDM or Ministry of Energy. This is from Pertamina, especially Pertamina Thermal Energy. Geothermal that has been utilized, Pertamina manage 13 geothermal working areas with 672 total installed operation power capacity megawatt, and 80% of total Indonesia geothermal installed capacity are within Pertamina Geothermal Energy or PGE working area. You can see some working area in this map. Kamojang is the best practice and lesson learned in Indonesia. Now in the best geothermal in the world is in Italia. And then the second, we have Lahendo. And then the third one, Ibayak, Karaha, and then the last is Umut Balai Unit Sat. This is the data from Pertamina Geothermal Energy or ladies and gentlemen, we know that thermal energy is included clean energy according to Article 1 number 21 of 2014 concerning geothermal energy. Geothermal is a source of heat energy contained in water, water vapor, and rocks, along with associated minerals and gases are genetically or transferable in a geothermal system, and for its utilization, it requires processes. And geothermal is non-oil primary energy that is renewable and environmentally friendly energy, and of course, clean energy. It is known from the low potential for exhaust gas emission, the small potential for gateway waste, hazardous and toxic materials, and development land doesn't worry the surrounding environment for Pertamina. And then utilizing geothermal energy will be an excellent alternative in the future. So even now we can make maximum use of it, and we have many potential area in Indonesia. And the fossil energy we usually use is decreasing, damaging the environment significantly as the gas emission release can deplete the ozone layer. And the enormous influence of fossil energy has impacted global warming due to the increasingly thinning ozone layer. So, therefore, geothermal energy as an alternative must start now. And the first important thing that geothermal energy is a clean energy, one of the alternative energy. And we must preparation to face the immense possibility of exhaustion of fossil energy resources in the world. And we know the fossil energy more decrease year per year. This is the utilization of geothermal energy. We talk about Indonesia, especially Nusa Tenggara and Sumatra. In Indonesia, geothermal energy has around 40% of the total reserve in the world. 40% is the amount, I think, the huge amount for this potential energy. Only about 2.4% of them have been explored and produced, and still small from 40%. So we have more potential to push this energy. Geothermal energy as a power generator has long been known, but not optimized now. If optimized, our dependence on oil, mainly obtained from import, will save countries' foreign exchange, And we can also improve the country's economy if we can optimize the use of geothermal energy, which is very large in our country, Indonesia. And apart from that, the environment in our country will be better, will be clean. And if we can reduce our dependence on fossil energy, oil and gas, which produce high pollution. This is some advantages: geothermal energy, clean, environmentally friendly, renewable energy, and then give what we call not only environmental justice, but give ecological justice. It doesn't depend on weather, supplier, availability of transportation, and loading and unloading facilities in fuel supply. It doesn't depend on the increase in the oil prices, which can change anytime. And then the last, can operate continuously, sustainability environment while carrying primary loads. And this is the benefit of developing geothermal power plant. Generates electricity, very huge, generating regional income, encourage infrastructure development, improve the economy, open job opportunities, tourism added value, and so transfer of science and technology development community community. And this is state revenue, central and regional from geothermal energy. We have some what we call state revenue, central and regional from geothermal development consists of PNBP and production bonus. And this is divided into the center, producing province and producing region, and can make bonus, production bonus are given to producing region. And we know now there are programs, Flores Geothermal Island, program Flores Geothermal Island, in accordance with Article 6 of Law number 30 of 1909 concerning electricity, primary energy sources must be used by prioritizing new and renewable energy sources. So this is the best choices, I think. But we must push and make all of stakeholder what we call safe, and through the people make safe. And the following Article 11, paragraph 1, government regulation number 79 of 2014 concerning national energy policy, energy development priorities, local energy resources. And with great potential and to fulfill the statutory mandate as renewable energy and local energy resources in Flores, geothermal is a priority for developing energy sources in Flores. And we know to realize geothermal energy as the primary energy source for generating electricity in Flores through the decree of the Ministry of Energy and Mineral Resources number 2268 K 30 MEM to 2017. Flores Island was designed as a geothermal island called Flores Geothermal Island. And the advantages of the geothermal energy as the primary energy source for generating electricity in Flores. Ladies and gentlemen, if we can push one of the potential energy in all of kind of energy in Indonesia, include the geothermal energy and all of the natural energy, I think public participation is the one important things to a good implementation regulation. I mean, good norm and good process for the regulation. Absolutely, public participation is an important thing. So in the law number 6 of 2023, this is the important thing in public participation is the meaningful participation must cover to implement it all of regulation in geothermal energy implementation in all of areas in Indonesia, include Nusa Tenggara and Sumatra. And law number 6 of 2023, there are 3 rights in this regulation: right to have his opinion heard, right to be considered, and the last, the right to obtain an explanation or answer to the opinion given. And we know from Zeri Einstein, public participation, there are 8 layers from the basic or the first layer is manipulation, and then the second is therapy, and of 2 of this layer, manipulation and therapy, this is the meanings of non-participation. And the third, fourth, and fifth layer, informing, consultation, and placation, this is the layer that degrees of tokenism or pseudo participation, pseudo or degrees of tokenism. And we hope our research give advice or recommendation. The best implementation in the policy, if we will push the geothermal energy to best choices, minimum the government and the people and also stakeholder can good participation, minimum in partnership, and better if delegated power and also citizen control can implement it. This is degrees of citizen power, partnership, delegated power, and citizen control. This is in the use of natural resources, at least at the partnership level. And this is legal issues in this what we call empowering geothermal energy, community, government, company, and community. In geothermal utilization, we can see Article 33 of the 1945 Constitution or Indonesian Constitution. There are distribution of benefits, and then participation, recognition of customer rights, and so also ecological justice. If we talk about the theory of ecological justice from Brian Baxter, from the Brian Baxter, the title, the theoretical of ecological justice, justice for not only human beings, people, and then what we call many trees, and then animals, and then the ecosystem, I think. And we can see distribution of production bonus to region and fair allocation to producing communities. And the government, we also in our research evaluation, the government regulation number 28 of 2016 concerning the amount and procedures for providing geothermal production bonuses. It needs to be determined by government regulation regarding the allocation of bonuses given in local area and central area, especially Section 2 and 3. This is our evidence, our visit in discussion with the regional secretary of East Nusa Tenggara Province, and then discussion with the chair and deputy chair of the regional peoples of Representative Council of East Nusa Tenggara Province, and discussion with region of Manggarai Regency, deputy chair of the regional peoples, Representative Council of the Manggarai Regency, and also we can do focus group discussion with friend from university and then NGO and the people. I think that's all my presentation. Thank you very much.
Thank you very much, Prof. Ayu. It's very impressive presentation about her research in East Nusa Tenggara and South Sumatra province. Prof. Ayu gives us issue about benefit of developing the geothermal power plant and also distribution of production bonus in region and allocation for producing communities, public participation, recognition of customary rights, and also ecological justice. Okay, ladies and gentlemen, if you have any question through Prof. Ayu, please kindly be patient because we will have Q&A panel after the presentation all the speakers. Okay, ladies and gentlemen, now we will move to our second speaker, Professor Nurul Bariza from Universitas Airlangga. Professor Nurul, are you still joining us? Hello, Prof. Nurul. Hello, Prof. Nurul. Are you still joining us? Technician, can you help me?
Can you hear me? I hear
yeah,
you.
Prof. Nurul, please turn on your microphone. Okay. Could you hear me clearly, Prof. Nurul?
I hear very clear.
Okay, thank you very much.
Can you hear me?
Yes, we hear you. Okay.
Okay, so I'm going to share.
Okay, are you ready, Professor? Okay, before
Yes.
that, allow me to read the short curriculum vitae of Professor Nurul Bariza. She is a professor of international law and the head of Quality Assurance Board, University Airlangga. She is married and he has 3 wonderful children. For her education background, she earned her Bachelor of Law, majoring in International Law in Universitas Airlangga, 1994. Then Master of Laws in Faculty of Law, University of Technology, Sydney, majoring in International Intellectual Property, and earned her PhD in Laws, Faculty of Laws, University of Technology, Sydney. Her dissertation entitled International Intellectual Property and Biological Resources. Prof. Nurul was the former Dean and Vice Dean for Academic Affairs, Faculty of Law, Universitas Airlangga. She is the member of Academic Board's National Academy of Professional Studies, Sydney, Australia, 2019 until now, and the member of Supervisory Board of the Surabaya Drinking Water Company, or PDAM Surya Sembada Surabaya, 2021 until now. She is also a country expert or assessor of International Accreditation, FIBA, Germany, 2021 until now. She has multiple publications, but the latest one is published in Journal of Intellectual Property Law and Practice 2021, entitled Plant Variety Protection Law and Farmers' Rights to Save, Exchange and Breed Seeds, The Case of Indonesia. Prof. Nurul will present her paper entitled The Challenges for the Protection of Intellectual Property Rights of Indigenous Peoples' Works under International and National Laws. Let's give our warm welcome to Prof. Nurul. Prof. Nurul, the time is yours for 20 minutes.
Thank you very much to Dr. Sri Wahyu. Do you hear me?
Yes.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Speakers, my friend, Professor Dr. Gusti Ayu, that already presenting the paper earlier, and also my friend, Professor Christopher Jason. Hello, nice to meet you again. And also all our colleagues and distinguished participants. Honestly, it is an honor for me to join and to have opportunity to be invited in this very important conference as a speaker. And thank you for Dr. Aryuni for make it very possible for me. All right, in line with the theme that given to me by the committee of the conference, I would like to move to different direction. If Professor Ayu talking about geothermal energy, so we are going to talk about the challenges for the protection of intellectual property rights of indigenous people works under international and national law. This topic is still very important topic and still relevant in today's context. When we are talking about social justice issue for this conference, although honestly that this topic has been discussed in number of forums and in number of arena since at the beginning of 2000. So let's know we are going to move what is the or who are the indigenous people before we going to talking further about the issue of this. So when we are talking about indigenous people, it can be regarded as like office people. In Australia, we call it Aboriginal people, or in different countries, we call it native people or autochthonous people. In this context, when we talk about indigenous people, mean that those who are culturally distinct ethnic group who are native to a particular culture. And a long time ago, in the era of colonialization, the term of indigenous was first introduced by European, and in modern context used to differentiate with the indigenous people of the American as slave from Africa. And then, what is the current context now? When we are talking about intellectual property right protection, the current context now is that we have to talk about the situation that we have to know exactly what are the indigenous people of Indonesia. As we understand that each country use different terms. Like Philippines, they use indigenous and cultural minorities. In Thailand, also use hill tribe. In India, call it by schedule caste and tribe. And in Malaysia, they call it orang asli. And in the context of Indonesia, the meaning of indigenous people is mean tribe group, tribal communities, or other communities. And you know that in Indonesia right now, it is estimated that 50 until 70 million other community live in our country now, and it accounts 18% of the Indonesian population. So let's move to the current context. Why this issue is very important, and why we're going to discuss today. You know that there is at the international level and international level as well, there is awareness of the importance of indigenous culture and indigenous traditional knowledge. But at the same time, indigenous people must fight harder to protect their culture and traditional knowledge from the number of threats and challenges. Why? Because, you know, there is a number of international treaty, there is a threat of globalization, liberalization of international trade with the stronger IPR protection. And the main problem is that when we talk about protection of intellectual property rights, and it's connected with the characteristic of traditional knowledge and traditional cultural expression, it seems very difficult for such knowledge and cultural expression to be protected under that conventional regime of intellectual property. The character, as I show you in this screen, that it handed down from generation to generation and also reflect community, cultural, social identity, and it is often made unknown on author is, that because it's already from generation to generation, and it regarded as belong to the community under the customary law. And another problem is that such traditional knowledge is still evolving, developing, and being recreated in the community itself. Now, then sorry. And as I told you, sorry, I'm coughing. As I told you that SACWORKS does not meet with protection of intellectual property with the notion of conventional intellectual property, as they are not novel, not inventive, not industrially applicable, and cannot be protected under patent law. And SACWORKS also regarded as public domain, and as well as different from the context of modern intellectual property rights. When we talk about public domain, some people can use it for development of new invention, and they can be used as a basic material for modern knowledge, innovation, and invention. And also, it can be protected if in the form of traditional knowledge-based innovation, it can be protected as invention, and then it because it's invention, so it will be protected under patent law. But the question is raised: is it fair, just, or is it ethical? Why? Because traditional knowledge and traditional cultural expression can be protected under intellectual property rights. They are regarded as intellectual property rights. But the problem is they cannot be fully protected by existing conventional IP system due to inadequacy of the system. And then it requires the adoption of the current IP form or the development of sui generis form of protection. So because of that, this can be considered unfair, and this unfairness lead to what we call the concept of what we are known with indigenous intellectual property. Because of the many claims by indigenous community over their collective of intellectual property rights to protect their specific cultural knowledge. Then the term appear under the international law, the collective rights, in which this collective right is opposite to individual rights. So after there is recognition about the right of intellectual property right of indigenous people works, whether in the form of traditional knowledge or in the form of traditional cultural expression, then also there is recognition about collective right. But do you think that the problem has been accomplished or has been settled? No. It arises also threats and challenges. The problem is still exists, since long time ago. What is that problem? And what is the challenges? The first is about misappropriation of indigenous knowledge related to genetic resources. Some call biopercy. And the second is about commodification of indigenous culture and it can be used in many forms, such like tourism activities that usually it happen in many countries in the world. So that issue lead to what we call is the question about distributive justice, because you know that many leaders in the world in 2001 during the what we call is United Nations Conference on Environment and Development raised the concern that such misappropriation use of genetic resources related to traditional knowledge, as well as what we call is biodiversity, has a problem with unfairness, and also has the problem with distributive justice. As the president of Tanzania, as I quote here, said that most of us in the developing countries find it difficult to accept the notion that biodiversity should flow freely to industrial countries, while the flow of biological products from the industrial countries is patented, expensive, and considered the private property of the firm that produced them. This reflects asymmetry and inequalities of opportunity, and this is that we call is unjust. So how international law deal with this problem? How international law would like to answer this issue? Distinguished participant of the conference. As I told you earlier, that this problem has been discussed in a number of international fora since at the beginning of 2000 or earlier than that in 1996. Many international organizations under the umbrella of United Nations has very significant big concern about this issue. They like to settle that problem by setting a number of forums. It's not only in the international environmental law under the CPD, Convention on Biological Diversity and Nagoya Protocol, but also in the international human rights. It is concerned about the right of indigenous people, and then also in the UNESCO, and also in the Food Treaty, International Treaty on Plant Genetic Resources for Food and Agriculture, as well as in the international IP law. So, distinguished participant of this conference, let's talk about the CBD. Under the CBD principle, it stipulates under the article earlier than Article 8G, state that Convention on Biological Diversity recognize the right of the right of traditional knowledge, or right of indigenous people on traditional knowledge. And this convention required the government to issue national law to encourage equitable sharing of benefit. Then the technical aspect of this can be seen in the Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefit from the utilization of the resources. And then after that, we can see in that Nagoya Protocol, all is, that talking about how national law should implement the benefit sharing, have to ensure that there is a prior among consent, and also there is what we call is the ownership of who hold the ownership of indigenous and traditional knowledge from the local community, and from which the consent can be get it from for its utilization. And then After Nagoya Protocol, let's move to the United Nations Declaration on the Right of Indigenous People. Distinguished participants of this conference, when we talk about United Nations Declaration on the Right of Indigenous People, one of the very important and crucial article is the Article 31, in which it states that the indigenous people have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expression. And in this context, this declaration also recognizes that right of indigenous people is part of human rights. And from this perspective, then, from this United Nations Declaration of the Right of Indigenous People, then make UNESCO and other international organizations have a strong willingness on how to regulate and how to respond the principle that has already set up in the United Nations Declaration on the Right of Indigenous People. And then it brings us to the UNESCO, in which in this UNESCO is talking about what we call is UNESCO is talking about tangible and intangible property, and then we can move to the what is WIPO going to do to deal with this issue. From the screen, you can see from the WIPO perspective, what is the term given to traditional knowledge. Many name of it, yeah. So we can choose which one that is appropriate and suitable for our context. And then, as I told earlier, that many United Nations agency also has concern about this issue. And one of the important thing of the WIPO work is that the establishment of the Intergovernmental Committee on Genetic Resources, Traditional Knowledge, and Folklore. It was established in 2001, but the mandate is still exists until now. However, even it has been established in 2021, but until now there is no significant achievement that has been achieved by this forum. The idea earlier is that WIPO should establish internationally legal binding instrument to settle this issue. But in the last session, last month, on September 8th, there has been international development for this forum, because this forum can propose international legal instrument on intellectual property, genetic resources, traditional knowledge, and related to genetic resources. And the draft proposal on international legal instrument is supposed to be concluded no later than 2024, next year. Hopefully that no later than next year, but I don't think it will be no later than 2024. And then I saw this is the draft that has been prepared by the WIPO that I already told earlier. And then, but as I told you earlier, that the approach that has been set up by WIPO since 2001 until now is still the same. That WIPO tried to settle the problem by establishing international obligation to require disclosure of origin of genetic resources used in the crime invention, and also try to promote coherent implementation of international obligation under the CPD and Nagoya Protocol. But there is a still issue that still exists until now, in which recognition of the right of indigenous and local community on the basis of human rights law and customary law is still, in pending question. And WIPO also already set up consolidated draft article, as I already show you, but the clear option for the approach to protection still in the context of defensive or disclosure requirement or offensive positive protection through existing intellectual property tool or developing a switching system for protection. So let's move to the national context now. When we are talking about national context, we cannot ignore our constitution on how our constitution recognizes our adat community in the amendment of 1945 constitution, in which the constitution affirmed the state recognition of the existence of the adat people. It's stipulated in the Article 18B, paragraph 2, Article 20X1, paragraph 3, and also Article 32, paragraph 1 and 2. And what is the realization of this? Until now, based on the several research conducted, and I searching in the journal, that recognition and respect for adat community are still far below expectation. Although Indonesia is signatory to United Nations Declaration on the Right of Indigenous People, but it seems that the concept of indigenous people is not applicable to the country. Probably the government regards that how to differentiate the indigenous and non-indigenous people is not known under Indonesian, what we call is concept. They talk about probably different context. Yeah, just only 2 minutes more. Going to see. Yeah, and then according to the report from United Nations Committee on the Racial Discrimination, it said that Indonesia is not respecting the principle of indigenous self-identification, and also when we talk about ILO Convention 169, the Indigenous and Tribal People Convention, it provides guidance on the right of indigenous people self-determination, but Indonesia has not ratified this treaty until now. So let's move to the how national IP law deal with this issue. There is 2 laws that deal with the issue. Also, some of the work of indigenous people can be protected under different IP law, like trade secret or geographical indication. But for the traditional cultural expression, we can see in the Article 31 of copyrights, in which state obligated to inventory and preserve traditional cultural expression. And then the use of traditional cultural expression must pay attention to value that live in the community where they are held. And then from that copyright law, the government issue regulation number 56, 2022 on the communal IP. In this, there is a need for documentation of the traditional cultural expression and traditional knowledge in Indonesia. And then let's move to the national IP law in the context of patent law. In the context of patent law, the law already stipulates defensive protection through disclosure of the source of origin in the Article 26. The law also set up the criteria for prior art, including orally expressed, and also disclosure of requirement to implement the CPD principle and Article 29 of TRIP agreement. But the challenges is that no legal sanction for the filer to disclose. And the challenges also is that no permission required for the owner of genetic resources traditional knowledge for its use in the invention. And in addition to that, patent, finish, first one. And patent can be removed if it does not meet the criteria of the Article 26 regarding the disclosure based on the third party claim. And the last thing, this last PPT, another biggest challenges that they are facing today in Indonesia under national law, when that's law stipulate that the inclusion of that disclosure of origin is to promote fair and equitable benefit sharing as stipulated under convention like CBD, Nagoya, International Treaty on Parental Resources. But until now, there is no such type of fair and equitable benefit sharing has been implemented. And another challenge is that when we are talking about fair and equitable benefit sharing, it seems like we are looking for charity. But this concept is not charity concept. This concept has been set up by international law that the distribution of fair and equitable sharing should be given to the resources country of the genetic resources related to traditionally in which they derive from. And the last thing that I quote the what we call is the statement from Prime Minister of Malaysia that we should treat different country, different people equally, and shall not be exploit each other. Thank you very much.
Tribal communities or adat communities. Indonesia is home to an estimated 50 to 70 million indigenous people, or 18% to 19% of the Indonesian population. And there is awareness of the importance of indigenous culture and indigenous traditional knowledge at the national and international level. But at the same time, indigenous peoples must fight harder to protect their culture and traditional knowledge from a number of threats and challenges. They need an umbrella legal term used in national and international forums to identify indigenous peoples. Prof. Nurul has explained about the development of international law through international forums such as International Environmental Law, Nagoya Protocol, International Human Rights, UNESCO Convention on Cultural Heritage, and also International IP Law YPO. Okay, ladies and gentlemen, if you have any questions, so please be patient because we will have Q&A panel after all the speakers deliver their presentation. And now we will move to the third speaker, Mr. Christopher Kaysen from University of Washington. And Mr. Kaysen, thank you for being here today because you are the only one speaker who's staying with us in this room. Okay, before his presentation, I would like to read his curriculum vitae. Mr. Christopher Kaysen completed his Master of Laws, LLM International Dispute Resolution at the University of Miami School of Law in 2019. He is currently a senior lecturer at Universitas Indonesia, Yogyakarta, and he has a vast professional experience, including senior consultant at PT Blue Vision Consulting Jakarta, international business law lecturer at Gangwon University in South Korea, and attorney at law in Washington, USA. He has multiple publications. The latest one is the Regulation of Defendants' Religious Identity in Court Decision, Besur 2022. His professional highlights include first, voluntary ESL instructor for orphanages in Jakarta and Yogyakarta, Indonesia, and Daegu, South Korea. And second, recognized as a rising star in Washington's Best Lawyers edition of Washington Law and Politics. Wow. Okay, third, Procurement and Development Committee member for Keystone Auction for Civil Works. And in this session, Mr. Christopher will deliver his presentation entitled Protection of Indigenous People's Rights. Let's give our warmest welcome to Christopher Kaysen. Professor, the floor is yours for 20 minutes.
Oke, Assalamualaikum warahmatullahi wabarakatuh. Namo Buddhaya, salam kebajikan. So, good afternoon. Thank you, all of you, for being here. Thank you to the committee, ICOLGAS committee, for inviting me here. Thank you to Pak Rector and Pak Dekan. And thank you for all, Mbak Ayu, for all of your hospitality and welcoming me to Purwokerto for the first time. I appreciate all of the participants who are here, as well as the participants who are online and unable to join us here today. So, can I get the presentation, please? Thank you. We'll see if this works. Sort of? Okay. So, I'd like to start off with a brief introduction of why, about indigenous rights, particularly in the United States. Okay? And recently, there was a case that was decided, or settled more accurately, dealing with indigenous fishing rights. So the Native American rights to fishing. And even though it doesn't seem like a significant case by itself, it highlights the history and the legal relationship between Native Americans and the United States government. And it also brings into focus some of the conflicts that happen between environmental interests, sustainability interests, and indigenous peoples' interests. And so we'll talk a little bit about the history and the law in the United States, and then about this case, the Sauk Seattle Indian Tribe versus Seattle. Oops. Next slide, please. Yes. Okay. So I normally don't want to talk about myself. I'm not that important. But my hometown is Seattle, Washington, in the northwest part of the United States. And the only reason that's important to this case is the city of Seattle was the defendant in this case. So this all started when one of the Indian tribes sued the city of Seattle. And of course, it brings back the very, very fraught history between the European colonists and the Native Americans. And again, the reason I put this picture of fireworks up here is there's a little story that reminds me of my childhood. Now, I know in Indonesia we celebrate Independence Day on August 17th. And it's independence from Dutch colonization. Well, in America, we celebrate Independence Day on July 4th. But it's a little different Independence Day. So it's the colonists celebrating independence from the British Empire at the time. And like many celebrations, we like to use fireworks. But this terrible thing came to my mind as I was thinking about my childhood and how much I love fireworks. I like to shoot them off here during Eid al-Fitr. I love fireworks. But then I remembered when I was growing up in my hometown, fireworks were illegal. You couldn't just go buy them in the store. So we would drive to the Indian reservation, which are lands that were set aside for our Native American population. Long story, but they could sell fireworks that were illegal outside of the reservation because they have semi-autonomy. And I thought of the irony of buying fireworks on an Indian reservation to celebrate essentially white person's independence. And it was because of that story that I thought about this sort of both unique and terrible history of our relationship with the Native American population, the indigenous population, and how that still is important today. We've been talking about indigenous people, we've been talking about sustainability from my esteemed colleagues, and so I'd like to take a little bit different angle on it. There is a sad history, thank you, sad history in the United States of this doctrine of discovery. Colonists called it discovery, and I don't think the indigenous populations felt quite the same about that. The colonists came to exploit the natural resources that were more scarce back home, and in exchange we brought disease, conflict, imposed monotheism, and some of the worst actions were the forced relocation of natives. During this process of westward expansion from the east coast of the United States to the west coast of the United States, we often forced native indigenous people from their land. And as part of that, we introduced acts of Congress in order to try to assimilate the indigenous populations into the European culture. And as you can imagine, that didn't go so well. So if you go to the next slide, please. Okay. By the way, just a quick note. May interchangeably use the words Indian or Native American, Native, and again, Indian comes from the fact that our first explorers got lost and think they landed in India rather than in what is now North America. Even the word American is Eurocentric, coming from the explorer Amerigo Vespucci from Europe. But that's sort of the names that we use both in our normal speaking and our laws. So I'll keep using those. Again, they are indigenous peoples. I think they're referred to as Aboriginal people in Australia. Sometimes they're referred to as First Nations people because the tribes were organized into nations themselves. Like Ibu Nurul mentioned about the Indonesian Constitution, the US Constitution, next slide please, sorry, does specifically mention Native Americans in the Constitution itself, again, referring to them as Indians. And what was most significant and what I think is most unique about the American system, and when I say unique, I don't mean good by any means, but it is unique in the sense that as America became the United States, the colonists and the formative government of the United States entered into treaties and treated Native American tribes as if they were foreign sovereigns. And so instead of treating them as American citizens, they were treated as separate countries. And as a result of this, negotiations with these tribes were done just as if they were a foreign country. And so in the mid-1800s, there were many, many treaties that were signed, both preserving land, reserving land for the native populations, the Indians, as well as giving certain rights to use those lands. And we'll come back to the fishing rights in just a moment. This is a brief history of the legal relationship between the 18th and 19th centuries. It's not a very pretty picture, to say the least. It mostly involved the federal government taking away rights more and more from the native populations. And into the 20th century, the next slide, I won't bore you with the entire history of Native American-U.S. relations in the hope for expediency. So in the next slide, we'll see a slightly better relationship during the 20th century. And this is where, even though there were less rights taken away, and there was greater recognition of the original treaty rights and tribal autonomy. And so laws went into place, funding went into place to support tribal autonomy, and particularly because this is a law program, particularly for tribal courts, which operate and have a mostly independent relationship from the state and federal courts in the United States. Next slide, please. So these are basically the three principles of U.S. Native relations. One is territorial sovereignty. And I know in Indonesia they have what they call semi-autonomous regions that maintain autonomy. But again, that autonomy, as I understand it, comes from legislation derived from the original 1945 Constitution, but it's still considered part of Indonesian territory. And so this territorial sovereignty in America still recognizes tribal land as separate sovereign property. It's a sovereign within a sovereign is how it's been referred to. Again, not to bore you with United States federalism, but any dealings with Native Americans are done by our federal government and not on the state or local level. So it gives plenary power to our Congress. And third, it creates this trust relationship, meaning that the United States government is trustee of the land that's held by indigenous people. There's a number of cases, because it's a common law country. Everything is done through case law, and these are cases dealing with reaffirming Native American autonomy and this trust relationship and this treaty relationship. So basically upholding the treaty relationship as we go along. And again, my paper goes into a little more detail about the genesis of this legal relationship, but again, in 20 minutes, we don't have time for that, or 5 minutes left, we don't have time for that. So I'd like to move on to the case that sort of spawned this, it sort of is a microcosm of this relationship. But first of all, next slide, please. As discussed in Australia and Malaysia and Indonesia, water is one of the most precious resources we have on our planet. And hearing about the right to clean, accessible drinking water as a human right. In America, it also is considered one of the most precious rights, especially in the Western United States. And the Native Americans, through these treaties, have about 30% ownership of most of the water accessible in the Western United States. So these rights are very important. The other right are Native American fishing rights. Move to the next slide, please. And as you know, especially in the South China Sea, that fishing rights, dealing with Indonesia's neighbors of the Philippines and Taiwan, and Malaysia and China, that fishing rights are vitally important. Well, they're also important in the United States. And they're essential to Native American sustenance and Native American culture. And these rights are guaranteed in these treaties that were signed back in the middle of the 19th century. But there's lots of other interests too. First, there's non-natives who want to fish as well, commercial fishermen. But it also goes in conflict with conservation groups who are attempting to conserve fish populations and other and protect the natural resources. So all these interests sort of conflict when it comes to fishing rights. Again, Native American fishing rights, thank you, have been upheld over and over again. So I won't, again, bore you with the jurisprudence. So if we could move on to salmon versus hydropower. If you would go forward one more slide, please. Okay. So hydropower is generally thought of as clean energy. Okay? It's basically the river runs through a turbine and that generates electricity. And in the Northwest, in a large part of the Western United States, most of the electricity generated comes from hydropower. And it's long been thought of as one of the greenest forms of energy, especially compared to burning coal, nuclear, or burning other fossil fuels. However, salmon, which there is no native salmon to Indonesia, is a unique creature. So a salmon begins its life in a freshwater river bed. Once the salmon becomes a little fish, it swims downriver into the ocean. It grows up on the shoreline and spends most of its life in salt water as an adult fish. The females then swim back to their native fishing spawning beds and lay their eggs for the next generation of salmon. So it's a unique fish, and I don't think there's anything similar, any type of fish similar in Indonesia. But salmon is very important in especially Northwestern Native American culture. I'm getting hungry right now just thinking about it. So it's very important. It's very important commercially. But however, it's in direct conflict with this hydropower. So this green power is decimating salmon populations because the salmon can't swim upstream. If you can see one of my previous pictures, the actual dam in conflict itself, here, yes, thank you. There's no place for it to go. Salmon can't go downstream, or they get, they don't want to think about it, and they can't go back upstream, as well as dams change river flows and destroy spawning areas. So if you go down to the next level, so this lawsuit was somewhat unique. Of course, the Native Americans sued the city of Seattle. The city of Seattle gets its power from this particular dam. So they sued for infringement of their treaty rights, basically violating the search and seizure amendments to the Constitution. They also sought jurisdiction of the tribal court. And third was their unique argument, and this came up earlier in our first plenary session, about the rights of non-humans and recognition of non-human rights. And what the tribe here, the Sauk Seattle tribe, said was that fish have rights to exist on par with humans. And this tribe has standing to protect the salmon populations on behalf of nature, essentially. And it was a novel argument. So, next slide, please. Essentially what happened, back one, thank you. Essentially what happened was the case settled. So unfortunately, there is no Supreme Court case that decides this. But given the legal ramifications, the city settled with the tribe. And ultimately, they're changing the structure of these dams in order to allow fish to swim downstream and swim upstream to spawn. So it's considered a major victory in balancing human interests, tribal interests, and conservation and ecological interests. However, the settlement didn't go far enough to say that salmon have rights on par with humans. So they wouldn't go that far because that would open up a number of implications that would change environmental policy. So in conclusion, thank you. It's been a long, fraught history between the Native Americans, and no part of it is good. However, it is unique, and some of the rights that the natives have today, the indigenous people have today, come from this history and this unique situation of treaty law. Unfortunately, or as a lawyer, fortunately, because lawyers make lots of money off of lawsuits, most of enforcement of these rights has happened in the court system. It takes the tribe having to sue the city or having to sue the government in order to enforce their rights. And so while the result here was good for the fish, as one of the articles cited says, it seems a shame that it has to happen this way, and it can't happen on a more efficient, collaborative way. And so I hope that was interesting a little bit about, even though it does not affect indigenous people's rights in Indonesia or anywhere else, Hopefully it gives a little insight into indigenous rights in my hometown. So thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much. It was mind-blowing presentation, Mr. Kaisan. Okay, Mr. Kaisan explained about history of native United States relation, unique treaty, rights fishing stocks with Indian trip versus city of Seattle. Mr. Kaisan also explained about three native U.S. legal principles, including territorial sovereignty, trust relationship, congressional plenary power, and also fishing and riparian rights still continue to test the relationship but on 175-year-old treaties and need to do a better job of protecting the human rights of indigenous people. Okay, once more, please give applause to all the speakers. Okay, ladies and gentlemen, now this is the most awaited moment, is the Q&A panel. So I will open Q&A panel for you, the participant in this conference room, also the participant who are online in Zoom meeting. You can raise your hand, mention your name, mention your institution, and please mention who will you ask to. And also the participant in Zoom meeting, you can raise hand or you can write in the chat room. Okay, first question. Man, over there, okay, please mention your name, institution, and who will you ask? 1, 2, 3, okay.
Well, thank you, Bu Moderator, for the time, and thank you for speakers from for presentation. Well, my name is Lutfi Hafiz Rafsanjani from Law Faculty, Universitas Diponegoro, Semarang, and I would like to ask a question, especially for Prof. Ayu, and maybe it's question for Professor Kaisan too. Okay, in our Constitution, the 1945 of the Constitution of the Republic of Indonesia, especially in Article 33, Paragraph 3, the land, the waters, and the natural resources within shall be under the power of the state and shall be used for the greatest benefit of the people. This article in our Constitution is emphasized that the environmental resources exploitations is for fulfillment the welfare of the people or welfare state. I think this contradict with the concept of environmental justice. My question is it necessary to re-enlighten our Constitution by adopting the concept of environmental justice? Well, thank you.
Get it, Professor? Yes. Get it? Okay, thank you very much. Okay, and the next, mention your name, mention your institution, and mention who you will ask.
Okay, thank you, Bu Moderators. This is an honor for me to asking special to Prof. Ayu.
Prof. Ayu, wait a moment. Prof. Ayu, are you still joining with us?
Yeah, by incident, he's my promoter for my doctoral program.
Okay, your promoter.
General Sudirman University. So, yeah.
Mister, I'm so sorry. Wait. Prof. Ayu, are you still joining with us? Okay, yes. Okay, go on.
Okay, nice to meet you, Prof. Ayu. Okay. Okay, I just want to respond about the presentations from Ayu that according by the research, but I know that many plans forward, particularly for plant electricity for plant, yeah. And then according to research that any kinds of based on the for plants like coal and then diesel and also nuclear more than and many there is a 10 and a potential damaging the the ecology. But yeah, therefore, why the governments decide the rules that any kind of forward plants must be closed, not operate anymore, and changing to find the power plant or energy, to find another like geothermal. But when I'm heard by presentation from IU that in Flores they have priority to make a geothermal for plants. I think that is a little bit contradiction because of the weather there is not only geothermal, I think, but power plant by solar cells may be more than potential than geothermal. I not have read and hear, and then this is my questions that did you ever compare that which one is better to make geothermal or solar cell for energy or electricity for plants? Sometimes I confuse because of we have as richest countries, we have many potential resources for power plant or electricity power plants. But actually the richest country have and keep technology, so on China, but we don't have. Until now, we didn't know why government not try to push and try to make a power plant anywhere. Exactly by the facts that Indonesia as a richest country, we can find solar cell as free, I think. So the question is, from IU, in your presentations, I not, cannot be found, and cannot to compare also that solar cell as alternative energy. For me, I think that it's more potential than geothermal energy. That is. Thank you very much.
Okay, thank you very much. And the third question.
Yeah, thank you. My name is Rahma from Universitas Islam Indonesia. Hello, Pak Kris. My question will be addressed to Prof. Ayu and Pak Kris. Yeah, for my first question to Prof. Ayu, it's about, as we know that we want to balance the interest of energy conservation and also to fulfill the national determined contribution by expanded a lot of renewable energy resources, such as Prof. Ayu already presenting about the geothermal energies, but as we know that the location of geothermal energy in Indonesia is mostly located in the conservation area, which is in the forestry conservation area. So as we also know that a lot of citizens in Indonesia also raise a protest about the establishment of those geothermal power plants. So my question is about that. Prof. Ayu also mentioned about the public participation in this context. So the exact question is how we ensure, and could you give us the exact measurement about the public participation in the context of this aspect, as we know that the determinations of the location of the geothermal mining and also to give the exploration mining, it should be based on the administrative decision. And as we know that the administrative decision is a one-sided legal action by the government. So which measure to determine the public participation to issue the keputusan tata usaha negara itself, ya, administrative decision. Those are my question for Prof. Ayu. And for Pak Kris, as we know in Indonesia, we also have a citizen law suite, Pak Kris, that the community on behalf of the ecological environment, we want to make sure that we have the environmental justice to our environment too. But as we know, the issue is that even though the citizen law suite was won by the community, the main issue in Indonesia is the execution of the judge's decision itself, Pak Kris. It's very contradict with your cases. It's very awesome cases you show to us. So please give a response about what happened in Indonesia to address the execution of judge court decision. Thank you, Pak Kris. Terima kasih.
Okay, thank you very much. Okay, I will give Prof. Ayu for the first turn to answer the question of the participant. Prof. Ayu, hello, Prof. Ayu. Are you ready? Okay, please turn on your microphone, Prof. Ayu. Okay, I'm so sorry, Prof. Ayu. Can you turn on your microphone? We haven't yet hear your voice. Hello, Prof. Ayu. Yes, okay.
Okay. Thank you for Pak Joni and Pak Surya and Bu Rahma for asking question, yeah. And some question for me. The first, Pak Joni from Undip, about the 1945 Constitution, especially Article 33, yeah, about the land, water, and natural resources that however the government must give environmental, not only environmental justice, I think, but also more than ecological justice. So that as I talk about this topic, this is our research in our groups, our research group, I mean in administrative law and energy law, and the issues about ecological justice in the natural resources, especially in this research, is geothermal energy potential in two locations, Nusa Tenggara and Sumatra. Today I talk about geothermal energy, and as we know, there are many alternative energy, like Pak Surya said, that Indonesia have more kind of potential energy or alternative energy, like solar cell. I agree with you, Pak Surya, yeah. But today I talk about geothermal energy. Maybe the next we want research together for solar cell. And about Pak Joni, the 1945 Constitution in Article 33, that I said that here government must make the first participation, public participation in the real implementation. As we know in Einstein theory about the participation, there are 8 layer participation, and I think today about participation in all of the policy or regulation. Still, I think second or third layer. So it's the meaning that there are no or small participation in policy and product, what we call regulation, yeah, legal product, not only in central government but also in local government. And this is the point, and this is very interesting. If we will the government policy or regulation from the government can good norm and good process and good implementation also. And I agree that Pak Joni said that very interesting and very important that actually the Article 33, 1945 Constitution, our Constitution, more implement not only environmental justice but also ecological justice. So justice for human, for fauna, flora, and also for ecosystem. I think that's all. And about Pak Surya, why the government decide maybe one power plant and decide to close one power plant and open another plant? I think in that I said today I talk about the potential of one alternative energy in Indonesia. We have many kinds alternative energy. We can do to research. I think many kinds alternative energy, because fossil energy to decrease per year. Yeah, fossil like oil and gas, and alternative energy is one of the solution. And this is the clean energy. I think I agree with you about solar cell. But today my research about geothermal, and our team recommendation that public participation is one of the issue about if government, if we will push the alternative energy, the government must make and firm and sure that the norm and that a good norm and good process in produce the legal product. I think that's all. And about basicing or keputusan tata usaha negara, I agree that must what we call cautionary principle in this topics. Yeah. And about natural resources, so precautionary principle, this is one of the important things for government to what we call to make basicing. Yeah, I think that's all. Thank you very much.
And now, Mr. Kezen, okay, this is your turn to answer the question.
Okay, thank you very much, and I apologize to the gentleman from Undip. I forgot your name. However, I think about Ibu Ayu basically gave the same answer I would regarding the clause of Article 33 saying for the welfare of the people. I think the view of environmental justice is that a clean environment is for the benefit of people, and that it must be the broader long-term look at benefit of the people rather than a short-term economic benefit. And I believe I'm echoing my earlier speakers in that sentiment that even if it is limited to the benefit of the people, clean environment, sustainable food sources, diverse ecosystems are for the benefit of the people. And so that should be read, I would say, to as how Article 33 should be interpreted. To my learned lecturer from Universitas Islam Indonesia, two things. Just a quick note on your first question, which was addressed to Ibu Ayu. Yes, location. We have the same problem in the United States in that where it's easy to generate alternative energy is not the places where we need alternative energy. We don't have solar farms or geothermal sites near big cities. And so, I can imagine getting the power from Flores to Jakarta is very difficult logistically. And so location is one of the biggest obstacles, I think, to recognizing, to reducing emissions in generating electrical power. Regarding your second question about the effectiveness of litigation in enforcing environmental policies, I guess it would be less of an issue of, it's not particular to the environment. It's what are the power of courts to, in a system of checks and balances, what is the power of the courts over the executive branch, which both operates and enforces the law. So if a court is ineffective in having the ability to force action of the executive branch, that's definitely an issue, a constitutional issue of separation of powers. And so, is it effective? We had a lawsuit in the United States similar to that in Montana, and basically the court, the constitutional court, similar, said this provision of the law is unconstitutional, and so it can't be enforced, and that the executive branch would be violating the constitutional rights by enforcing it. Again, I'm showing my ignorance about Indonesian law. And I don't know if there is such thing as what we call injunctive relief, where a party can be forced to actually take action instead of just damages. I'm not sure exactly what that mechanism is, but that would be, in my mind, how, the power of the courts to enforce, to give teeth to both environmental regulations and citizens' litigation for those, to enforce that legislation. So it's the independence of the judiciary, I think, is a big issue. I hope that answered your question. Thank you very much. And I think that's it.
Okay, thank you very much, Mr. Kaizan. Okay, ladies and gentlemen, there's such a wonderful discussion, but unfortunately, the time has come to end this session. So, but before that, allow me to wrap up once again our fruitful discussion today. There is still challenges for the protection of intellectual property rights of indigenous peoples works under international and national law, and need a regulation for indigenous peoples' claims of collective intellectual property right to protect specific cultural knowledge of their groups. We need certainty of rules and implementation about indigenous people right on fishing and riparian right. The interests of city should not violate the interests of the indigenous people, like you say. And the similar case happening also in Indonesia. Other communities as indigenous people need special regulation in national law, and also we should give attention to to regulate two policies regarding alternative energy for nature conservation. Okay, ladies and gentlemen, please give applause to all the speakers. And on behalf of the Faculty of Law, I would extend my deepest gratitude to all the speakers. First, Prof. Ayu, thank you very much, Prof. Ayu and Prof. Nur, who are join us online via Zoom meeting. Thank you for staying with us. And also, Mr. Kisan, thank you for being here. And thank you for your generous time and knowledge sharing that I believe discussion is nothing but insightful for all of us. And ladies and gentlemen, I hope we can see you in the next future, or in the next international conference held by Faculty of Law. And once again, thank you very much, and see you, and I will return the time to the MC. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you to Mrs. Dr. Ayu. I invite the speakers of plenary session 2 to hand over the certificate and trophy. The certificate and trophy will be given by Vice Dean Faculty of Law, Profesor Dr. Kadar Pamuji SHMH. The Honorable Professor Dr. Kadar Pamuji SHMH, please come to the stage to hand over the certificate and trophy.
Thank you very much. And to all speakers who join with us online, we are going to send all the certificates and also the trophy later on by the committee. So yeah. So ladies and gentlemen, you may have a coffee break near the entrance room. And please be ready at 3:30 p.m. waktu Indonesia bagian Barat in the room that has been plotted by the committee. And all participants are expected to return to the ballroom at 8:30 p.m. waktu Indonesia bagian Barat for the announcement of the best paper, the best presenter, and also public information.
Baik, Bapak Ibu, kami beritahukan bahwa coffee break telah kami sediakan di depan pintu masuk dari ballroom ini. Silakan Bapak Ibu dapat menikmati sajian dari coffee break, dan Bapak Ibu silahkan nanti langsung mengikuti parallel session sesuai dengan ruangan yang telah ditentukan. Dan kami akan kembali di sini, kita akan berkumpul kembali di sini pada pukul 9 malam nanti untuk menyaksikan bersama the best paper, the best presenter, dan juga public information. Baik, Bapak Ibu yang ingin membeli oleh-oleh khas Purwokerto juga dapat mengunjungi UMKM yang berada di depan ballroom. Di sana tersedia kelanting, sale goreng, keripik belut, dan lain-lain dari UMKM Toko Kedung Jati. Selain itu ada juga koleksi batik dari Batik Jiwarna untuk oleh-oleh yang bisa Bapak Ibu beli untuk dibawa pulang ke kota tercinta.
We also inform to all participants who need some health assistance. There is also a team of health workers from RS Emmanuel Yakum Banjarnegara. To those who need help in terms of like any health issues, you can be accompanied by the committee and can actually see the health workers outside of the ballroom. Thank you very much.
Ya Bapak Ibu, kami sampaikan bahwa ada pos kesehatan di lantai 3, bisa cek gula darah dan juga tensi. Partisipasi rumah sakit dari Emmanuel Banjarnegara bagi peserta ICOLGAS. Kami ucapkan terima kasih juga kepada Bapak Ibu yang telah hadir secara online, seluruh Kepala Kejaksaan Tinggi seluruh Indonesia dan juga jajarannya, juga Kepala Kejaksaan Negeri beserta dengan jajarannya yang berada di seluruh Indonesia. Terima kasih atas kehadirannya. Baik Bapak Ibu, kami ingatkan kembali Bapak Ibu silahkan menikmati hidangan coffee break dan silahkan Bapak Ibu bergabung di masing-masing ruangan untuk melaksanakan parallel session. Dan silahkan nanti kembali ke ballroom pada pukul 8:30
Itu dia
malam.
pemirsa kegiatan International Conference on Law, Governance and Social Justice Fakultas Hukum Universitas Jenderal Sudirman yang dimulai dari nyanyian Indonesia Raya hingga pengisian dari pembicara-pembicara luar biasa yang dibagi menjadi 2 sesi dengan diskusi tanya jawab. Terima kasih pemirsa sudah mengikuti International Conference on Law, Governance and Social Justice Fakultas Hukum Universitas Jenderal Sudirman. Saya Pita Septiana dan tim kru yang bertugas undur diri. Terima kasih, sampai jumpa. Alright ladies and gentlemen, this is closing for the International Conference which started from singing Indonesia Raya and filled by amazing speakers with Q&A discussion. Thank you for joining the third ICOLGAS International Conference on Law, Governance and Social Justice Faculty of Law, Jenderal Sudirman University on October 4, 2023. Pita Septiana and all crew Banyumas TV, see you on the next program.